actually do think I think I already saved the. I'm pretty sure I saved our king decision. I'm pretty sure I did that. Let me see here. Let me see. Otherwise, I'll just re-download it. But come on. Okay. Come on. You know what? Looking for is gonna take too long. Let me. So if we're reading today, because I can't read and do this at the same time. So let me quit this. Come on. Can I? Let me kill this. Oh, did I break it already? Okay. We're going to now let's actually go ahead and all right, Supreme Court decision, right? What's it called? Immunity. Supreme Court immunity, right? Supreme Court ruling immunity. Okay. Immunity. Let me get the actual text here. Nice. And I do want to actually save it. Yeah. I'm gonna save it. I installed a new internal hard drive, so some of my stuff aren't necessarily where I remember them being, so I do apologize. Cool. I think resources, right? Papers and postings, stream research. I think, you know what, my stream research, Supreme Court. See, when I go to re-download it, I realize that this is where I actually already had it. How lovely. Can I open? Okay, well, let me just open with Acrobat here. Cool. All right. So, me cancel, put you back in Google. I've got to stop doing that. Just give me regular Google. Boom. Okay. And all right. Nice. It's 119 pages. Now, what I want to do before we get started, if I'm not mistaken, right, there's the opinions. If I'm not mistaken, there's like opinions in the court, and then each judge then goes into their own personal opinions on the matter. I think that's how it works. Or is it that it was only the dissenting judges? I feel like it would be every single judge. You got Justice Thomas. Let me see. We have Justice Thomas. Come on. Justice Thomas. This one is Justice Barrett. Oof. Justice Sotomayor. That's the third one. A lot of text. Hold on. Oh, wait. Come on. Let me move. I need to move my chat thing out the way. There we go. Justice Sotomayor. That's the third one, right? That's our third guy. Yo, he wrote so much. Jesus. Okay, there goes Justice Jackson. So that's number 4. Who is dissenting. Come on. Jesus Christ, she wrote a lot too. That's it. Okay, so maybe that is what it is. All right, well, I guess we are reading 119 pages. All right, so what I know up front about this, okay? So essentially, right, our head of the executive branch, so i.e. President of the United States, is going to be immune from criminal prosecution whenever it deals with anything related to his core duties as President of the United States. Now, when I originally heard this and all the different things, all the snippets of stuff that I read, the way I understood it is that anything that was directly tied to being authorized by the Constitution, the president cannot be prosecuted for. That's a hell of a broad immunity grant going, but they did lay out some restrictions. They said there are certain things that's like absolutely immune, and then there's things that's presumptually immune. And the presumptual is the restriction part of it, where it's like, okay, this is clearly part of his duties. However, if it can be proven that prosecuting this doesn't encroach basically into his core duty as president of the United States, then he could be prosecuted for it, which it is a hell of a high burden to try and breach for quite a couple of reasons. But there's those two things that we are going to see. We're going to try and figure out what is going on with it. So no, I don't want my redact button. I need my highlighter. Do I not have a highlighter on this thing? Come on. Blah, 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 full sign, redact. Where is the highlight thing on Acrobat? On the actual Adobe Acrobat, there's a highlight. Is it in the comment section? It's in the comment section. You know what? Maybe the comment section we'll use anyway. Because here's our highlight anyway. Yeah, okay. Oh yeah, and then I can add comments. Cool. Okay. All right, so let's get started here. So, going to go ahead. So, federal grand jury indicted former President Donald J. Trump on 4 counts. Let me zoom it up a little bit for you guys. On 4 counts for conduct that occurred during his presidency following the November 2020 election. The indictment alleged that after losing the election, Trump conspired to overturn it by spreading knowingly false claims of election fraud to obstruct the collecting, counting, and certifying of the election results. So, this is actually, am I still on the highlight? I am. Can I turn the highlight off? Because I don't want to highlight unless I'm trying to. Okay, so this is interesting because like this is, so I love that this is probably the only point that they're going to bring up, because a lot of the other stuff that he's being charged with also happened after his presidency. So the thing I'm worried about is the knock-on effect from this ruling. And by knock-on effect, I mean, so obviously if it's going to be the case that his presidential duties is immune from prosecution, right? It could be the case that if he does an action while president that's immune, and it has a follow-on effect that he participates in after he has already left the presidency, will it still be immune? Or is it by virtue, because it all stems from a presidential action, that he would still be, right? That he would still be immune. He can't be prosecuted. So when he took the documents, right? Because I'm going to be referring to the documents case, right? He took the documents while he was president of the United States, right? If we was to just sit there and say straight up, he's president, immune. All of the stuff that happened afterwards when he wasn't president is not supposed to be immune. However, because he took the documents while he was president, could it be argued that because of that, all of these subsequent things that happen as a result of his presidential action can't be prosecuted? That'd be a good question that I want to figure out. But I'm already reading a little bit too ahead, and we haven't even read the first paragraph. So let's just keep going. So Trump moved to dismiss the indictment based on presidential immunity, arguing that a president has absolute immunity from criminal prosecution for actions performed within the outer perimeter of his official responsibilities, and that the indictment's allegations fell within the core of his official duties. The district court denied Trump's motion to dismiss, holding that former presidents do not possess federal criminal immunity for any acts. The D.C. Circuit affirmed. Both the district court and the D.C. Circuit declined to decide whether the indicted conduct involved official acts. So this is going to be their entry point here. Official acts. This is going to be their entry point, because if I'm not mistaken, this was then after this ruling, then like the whole case thing was then kicked back to the lower courts to now hash out this part, the official acts business. So held under our constitutional structure of separated powers, the nature of the presidential power entitles a former president to absolute immunity from criminal prosecution for actions within his conclusive and preclusive constitutional authority. Am I reading this right? Right? Under our constitutional structure of separation of powers. If I think about it, off the top of my head, I actually don't think there is anything. The closest you have is the legislative branch. Is the legislative branch when it comes to the impeachment and conviction of the president. However, that's not a criminal prosecution. So maybe that's where they're basing it off of, because outside of that, you don't have a mechanism for we actually have a mechanism for charging the president of criminal acts, because it'd be kind of weird. I guess I'm trying my best to try and like see it under their lens, because I guess it would be kind of weird him being head of the executive branch, and the executive branch is the one that does prosecutions and handles all criminal matters. Can the snake eat itself? Can the snake bite its tail and swallow itself whole? Maybe not. I don't know. Let's keep reading. There is let's see. Constitutional authority, and he is entitled to at least presumptive immunity from prosecution for all his official acts. Okay, so at least presumptive. There is no immunity for unofficial acts. Page 5 through 43. There is no immunity for unofficial acts. Oh boy, we're gonna see how that goes. This case is the first criminal prosecution in our nation's history of a former president for actions taken during his presidency. Determining whether and under what circumstances such a prosecution may proceed. Did you vote for Biden? Did I vote for Biden? Yeah, I believe I did. Yes, I did. I had voted for in 2020. Yeah, in 2020, I voted for Biden. Right, 2020 was the election. Man, I'm even getting old now. Time is starting to catch up with me, but I did vote for Biden. In 2016, I did actually vote for Hillary, and so to be fair, right? I only voted for them because my actual Republican nominees that I actually were like voting for didn't make the cut, because obviously Trump's the head of the Republican Party at the moment. Because like I really wanted John Kasich or Marco Rubio. They had like some decent. John Kasich was my number one. Had some really good policies that I thought was going to work out really well. And then of course he didn't make it. So but if I was to actually go back, I would have changed my vote from Hillary Clinton to Donald Trump, because I think Donald Trump's presidency was very needed for the U.S. and the rest of the world, right? Because now people take politics a little bit more seriously, right? They don't just sit there and just let old people just be the only ones to vote and then decide how everything matters, right? Now everybody sees that like when you just leave that ish be and you got somebody crazy enough, right? Oh man, can a lot of far-reaching ish, really come down on you, especially on the international stage. So I actually would have changed my Hillary Clinton vote to Donald Trump, seeing that. But obviously, I wouldn't want this man run for president. And now after January 6th, January 6th especially. So just think, right? If there was just enough Republicans that actually felt like the handful that did about the election being stolen and everything like that, we would have actually had democracy would have been over from that point forward, right? Would have actually had killed democracy, and the votes would have been like overturned overnight. It would have been wild, right? But people were relying. That's the thing. People are relying too much on all these safeguards. All these safeguards that we have in our Constitution are not foolproof, right? You just need enough people in certain places to like screw all that over. So let's see. This case, blah, blah. Oh yeah, I already read that. The nature of that power requires that a former president have some immunity from criminal prosecution for official acts during his tenure in office. And this part is true, right? We don't want the president to feel like every single thing he does can come back to bite him, right? That's why like during military conflict and stuff, why we can just like axe off like certain terrorist people without due process. Because if you think about it, every time like we knock off a terrorist head, right, we're violating a lot of different things in the Constitution, like due process, right to fair trial and everything, unreasonable punishment, blah blah blah. That obviously doesn't apply, right, because the president is able to carry out that assassination power for threats to the country. So this is the case. Oh yeah, I forgot. Does this work? Let me see. Can I? Oh, I don't have my thing up. Nope. Oh well. I'm gonna have to try it next time. I forgot. Let me see. Tell me, does it work? No, it doesn't. No action. I knew it. Man, this stuff is so hard. Bro, the application, so the actual bot application, the physical application on my computer is extremely complex. It took me it took me about 2 days of like really drilling down to like try to like figure it out. So, and I started getting it. That's why I can do all this other stuff, because like my animation thing with the trap card and whatnot, all that's done through the bot that I designed myself. With the exception of the actual Among Us flying in space. But like everything else is just it's pretty complicated, and I have a lot of work ahead of me, but we'll get it going. But yeah, see, so occasionally that was another thing I added to. So now occasionally you get a little Pokemon, right, that'll pop up, right, that people will be able to interact and catch with. I think as of right now, I think it actually only responds to one particular platform, and I have to figure out how to get it to work on all three. And we will get that going soon. Soon I will be a very, very nice streaming machine over here, right, that has all these features that nobody else has. Yeah, and then as a matter of fact, oh yeah, let's turn that off real quick, because you don't work, right? I'm disappointed. Hold on, I just want to turn that off. Turn the relay mode off. Okay, so we don't do that. Do you think Trump made the Republican Party look very bad? So, to be honest, it's not that he made it look bad. It's just the problem is that all our sane people in the Republican Party left. I don't know how much you remember, but like during Trump's like initial presidency, I want to say like in the first year, we had a crazy amount of exodus. Where like we had so many people in the Republican Party like dip out, and even like the prominent ones that probably would have had a good case for like even running for president, like Paul Ryan, right? Because I thought Paul Ryan was like fairly popular within the Republican Party. That man's nowhere to be found. I haven't heard or seen anything to deal with Paul Ryan after that man bounced. And that was like later on. I think that was like 2-3 years after during Trump's presidency. But yeah, like these people like just vanished, and then all you had left is just all the extreme people. I don't want to say they're all extreme, but holy shit, do they have like jelly for spines? Because like some of these people like just won't stand for like their original values and whatever like points that they stood for. I think I am about to put this sweater on. Freezing, man. All right, let's keep going. And then also too, if you can, like, if my microphone ever sounds crazy, because I think I have like some random issue as of right now where like the robotic noise might come back, and I'm trying to like lock down on that, which I think I might know, but I just won't know unless it happens. So definitely do, if it ever happens, let me know. All right, but let's get back with this document here. Let's see. So, blah, blah, blah. I guess I'll just start back right here, right? This case, no, I already read that. Damn it. The nature of that power requires that a former president has some immunity. Yep, we read that. Okay. At least with the respect to the president's exercises of his core constitutional powers. See, this is what I mean. Core constitutional powers. This immunity must be absolute. Oh, actually, yeah. So here we go. This immunity must be absolute. This I will for certain highlight. All right. Cannot be challenged. All right. Because that's what this means. That's what that means, right? Core constitutional powers, this immunity must be absolute, right? So under no circumstances can this ever be questioned, his immunity. Boy, is that crazy. That is crazy. As for his remaining official actions, he is entitled to at least presumptive immunity. Okay. Article 2 of the Constitution vests executive power in a president of the United States of America. Blah, blah, blah. The president has duties of unrivaled gravity and breadth. Okay. Trump v. Vance. Blah, blah, blah. His authority to act necessarily stems either from an act of Congress or from the Constitution itself. What I'd be interested in knowing is that absolute immunity from constitutional powers. I wonder if what they meant to, what they're angling for is that the core thing, so the things actually written in the Constitution itself are absolute, and then the things that can be derived from the Constitution. So, for example, Congress passing a law to empower the president to do something, it would only be presumptive and not absolute. That'd be an interesting distinguish. It'd be interesting if they make that a distinguished like point. Excuse me. My vocabulary sucks, I know. In the latter case, the president's authority is sometimes conclusive and preclusive. I think it's going to really help. Jesus Christ, it is going to really help if I make sure I understand these words as they are being used. All right, preclusive, preventing something from happening or making it impossible for it to happen. So when they say conclusive, right? So conclusive meaning like it's a determinative, and then preclusive would be before the fact, I guess. In the latter case, the president's authority is sometimes conclusive, right? So the absolute, and then preclusive, which I guess you could say like preempts a lot of things. When the president exercises such authority, Congress cannot act on and courts cannot examine the president's actions. It follows that an act of Congress, either a specific one targeted at the president or a generally applicable one, may not criminalize the president's actions within his exclusive constitutional power. Neither may the courts adjudicate a criminal prosecution that examines such presidential actions. Okay. The court thus concludes that the president is absolutely immune from criminal prosecution for conduct within his exclusive sphere of constitutional authority. Man, we should spend some time actually reading Article 2. I think that's what we're going to do. We're going to end up reading Article 2 of the Constitution so I can really understand. I think we'll do that like after we read a couple of pages. I'm gonna just throw it up in my Google thing here real quick so I know. Article 2 of the Constitution. All right, so I have it already loaded for later. Okay. Let me just, yeah, okay. Trump events is a Constitution itself, latter case. I stay losing like where I was. Jesus Christ. Okay. Not all of the president's official acts fall within his conclusive and preclusive authority. The reasons that justify the president's absolute immunity from criminal prosecution for acts within the scope of his exclusive constitutional authority do not extend to conduct in areas where his authority is shared with Congress. This is a very good one right here, actually. So this is actually really good. So that means like anything in which he has like a dual role with Congress is not immune, or does not at least have absolute immunity. The reasons that just represent absolute immunity from criminal prosecution for acts within the scope of his exclusive constitutional authority do not extend to conduct in areas. So okay, so anything shared. And I don't like that they said Congress. I would have hoped that this would have also included the judicial branch as well, but I gotta actually like relook at that because I'm actually confused now thinking about it. If he's immune from criminal prosecution, and he's head of the executive branch, what exactly is the judicial branch? Just exclusively just the Supreme Court? I thought it was like I don't know why I thought it was the entire court system altogether, but maybe it is just the Supreme Court, and that's just the judicial branch. I don't know. Anything shared with Congress is not granted absolute immunity. So this is good because this means that the vice president, right? Because the vice president has a role. He belongs to the executive branch, but he has a role in Congress, right? As president of the Senate. So his actions with trying to get Pence to like basically to overturn the election for him couldn't possibly be seen as immune because because the vice president thing is a shared role. It's a shared role with Congress, right? He has the power to like say and do whatever he wants with his officers, but his officer has a role in Congress. When they said this, does this mean that it's only things shared directly with Congress between the president and Congress, or does that extend to the things underneath the president that's shared with Congress? That'd be a good. Where I need my Notion. I need to get Notion up. Hold on, because I'm gonna have to. Some of these I'm gonna have to actually write down for sure. Hold on, I gotta open up my Notion page here. That's going to be, God, Jesus Christ. Hold on, inbox. Sorry, I am logging in. I am logging in. No, hold on. Oh, can I just sign in with my? Can I just sign in with my email? Bet. See, I don't even have to go through my inbox now. Okay. Okay. And you know what? I did it on the wrong browser anyway. I don't want to use that browser. I need to use this one. My Firefox. Hold on. Again. Gonna continue with Google. Come over here. Go here. Hold on. All right, cool. We have our Notion page here. And I have to clean up my notes section too, man. I gotta stop. There's so much to do, man. I need money. I so need money because I was so hire people to like help me with some of this stuff. Jesus. Class notes. We'll just do it on the class notes. And can I no class. Can I make a new class and then call it hold on. Class. Can I make a new class? Oh, do I just make a note? You're editing a template in class notes. I thought I was creating one. Okay, whatever. I thought I was creating one, but all right, fine. Templates. Empty. Okay, so we're going to call this Supreme Court, right? Supreme Court decision, and this is the immunity. Oh, right. Presidential immunity. The class, right? Topic, yeah. Stream. New stream and classes. All right, cool. And for a topic, this will be government. All right, so I'll make a government. YouTube channel. I have a very bad habit of wanting to be wanting to be perfect with everything that's set up here. I am actually going to grab this here to put it in here. Let me go like that. This YouTube channel. All right. Boom. Okay. And continue with an empty page or pick a template. Okay, now I know what that's for. Right. Okay. I guess I'll just do a bullet point for right now. I guess in bullet form for questions asked. Bulletless. Okay. Does president... Can I pop this full screen it? Yes, I can. And actually, I'm gonna have you on the right, and then I'll have this text on the left. You can close that. Let me open it up some. And go like that. Okay. Looks good. Okay. And I want it just a little bit. So what is that, like 210? Okay, let's do 220. 220. Okay. All right, awesome. Okay. So the question I do have for this is that if powers, or let's see, the reasons that justify the president's immunity from criminal prosecution for acts within the scope. Okay. If acts within the scope of constitutional authority, if acts within the scope of constitutional authority are shared between the president President and Congress are not granted absolute immunity. Does this include things underneath the president, or only things tied explicitly? But see, even based off of how you read that, because even if I said tied exclusively to the president, exclusively to the president. See, even saying it like that, that's essentially the same thing. But whatever, I'll clean it up another day. Okay. Does this include things underneath the president, or only things tied explicitly to the president and Congress? Right? Like if I thought about like war power. Like war power stuff is tied exclusively to the president, right? That can't be, I don't think that can be delegated down like certain other things the president can do. But I don't know, right? This is all new ruling, and obviously we're not going to have anything to really go off of on this. Can I do 240? Does 240 fit perfectly? 240 is good enough. Okay. And what I'm going to want to do, and questions. Bruh, come on. Click. Alt click to add a block above. Alt click to add a block above. Okay, yeah, there we go. I just want a heading. Right, and then let me cut that. It should. Why are you not letting me type nothing? Oh my god. See? Don't worry. Like, it just, practice makes perfect, okay? Like, once we do this enough times, it won't be this won't take us nearly as long, right? We'll have things nice and neat place. It's like 30 seconds, right? They'll just get it going. All right, so we got that. Now let's go and continue. Let's see. So determine, move you over here. To determine the president's immunity in this context, the court looks primarily to the framers' design of the presidency within the separation of powers, president on presidential immunity in the civil context, and criminal cases where a president resisted prosecutorial demands for documents. Huh. Is that a direct reference to Nixon? Because I think Nixon was trying to prevent Congress from getting what? Like, wasn't it like the tapes? Right? What is it? The Watergate? Watergate tapes? It'll be interesting. The framers designed the presidency to provide for a vigorous and energetic executive. Federalist Papers, blah, blah, blah. They vested the president with supervisory and policy responsibilities of utmost discretion and sensitivity. Nixon v. Fitzgerald. Yeah, see, I knew it. I knew he was going to reference him. Appreciating the unique risks that arise when a president's energies are diverted by proceedings that might render him unduly cautious in the discharge of his official duties. The court has recognized presidential immunities and privileges rooted in the constitutional traditions of the separation of powers and supported by our history. Blah, blah. In Fitzgerald, for instance, the court concluded that a former president is entitled to absolute immunity from damages liability for acts within the outer parameters of his official responsibility. So when they say liability, though, wasn't Fitzgerald, isn't that like civil lawsuits? I could have sworn that was like civil lawsuits, wasn't it? I think that's civil lawsuits. We are actually going to have to pull this up. Is any of this clickable? No? Okay. Fitzgerald. We will actually have to pull this up. I think they're referring to like civil liabilities, right? So like the president can't, like, you can't sue the president like for monetary compensation or anything like that. Fitzgerald. Nixon v. Fitzgerald. That's probably how you want to do this. I think. I might be getting completely mixed up with something, but let's see. In 1968, Fitzgerald, then a civilian analyst with the United States Air Force, testified before a congressional committee about inefficiencies in cost overruns in the production of the C-5A transport plane. Roughly 1 year later, he was fired, an action for which President Nixon took responsibility. Fitzgerald then sued Nixon for damages after the Civil Service Commission concluded that his dismissal was unjust. Yep. Whew. I'm glad we're reading this. Whew. God, look at all these old people. Jeez. Anybody I recognize? Nah, so all these people are long gone. Yeah. Black Mun. Okay. Okay, so yeah, so I was right. So yeah. So like I said, that Fitzgerald case just basically you can't sue the president monetarily for anything. Like any civil complaints you had against the president is dead on arrival. So that's what they were referring to here. In Fitzgerald, for instance, the court concluded absolute immunity for damages, blah blah blah. We read that. The court's dominant concern was to avoid diversion of the president's attention during the decision-making process caused by needless worry as to the possibility of damages actions. Oh, that sounds horrible. Of damages from action stemming from any particular official decision. By contrast, when prosecutors, Jesus Christ, has sought evidence from the president, this court has consistently rejected the presidential claims of absolute immunity. During the treason trial for former vice president, why did I bring up the vice president? Aaron Burr, for instance, Chief Justice Marshall rejected President Thomas Jefferson's claim that the president could not be subjected to a subpoena. But a subpoena from who? Hold on. A subpoena from Congress is a bit different than like a subpoena from like a criminal like court case, right? Because my understanding about this immunity is that like if it's a question about something that deals directly to a core power of the president, it can't be questioned, period. So you're not subpoenaing anything, right? But this obviously doesn't extend to like when Congress wants to subpoena something, because Congress isn't a criminal. It's not a criminal like action. So I mean, I guess you could argue like maybe the contempt in court, contempt in Congress, I mean, and stuff like that could have some, you know what? I actually wonder now. That's a very good question. I have to actually ask that, right? So we know, hold on. So does congressional contempt in court, contempt in Congress, congressional contempt in Congress have any effect if it was the president that defied a response from Congress? I'm curious, right? Because didn't they charge they charged the Department of Justice head, I can't remember his name right now, but basically like Biden's attorney, right, with contempt in Congress. I wonder, couldn't Congress just subpoena the president directly? And if the president refused, did they subpoena the Justice Department, or did they subpoena the president? We're looking at that someday. I'm gonna make a follow-on question. When Congress subpoenas, right? Is that how I want to pose the question? Right. I mean, I'm thinking. Yeah, I guess so. Subpoena. When Congress subpoenas someone for documents, i.e. the president, right? Because then they could subpoena the president directly, right? Oh, you know what? I already have my answer. The documents doesn't necessarily belong directly to the president. It belongs to the Justice Department, because the Justice Department is the one that recorded it. So you can't subpoena. I guess you can't subpoena the president for something that he doesn't technically have custody over. Yeah, he wouldn't have custody over it, right? It'd be the Justice Department, because it's an investigation through the Justice Department. Even though he's the head, which is another question, because he's the head of the Justice Department. So couldn't you just subpoena him directly and say because you are the de facto head of the entire judicial system, I can just subpoena you directly? That's a good. Well, we're still going to make this question. When Congress subpoenas someone for documents, i.e. the president, i.e. the president or the just, i.e. the president, can Congress subpoena the president? That's right. The president directly for documents. For documents. The president is head of the Department of Justice. So wouldn't he have technical control over the records as well? Bro, why is my spelling so trash? Over the records as well. Yeah. And then tab. Just type that there. Or yeah. Yeah. Okay. So, and that is by contrast when the president, okay, during the treason trial, blah blah blah, subject to a subpoena, that the president could not be subject. Yeah, and I'm going to mark this as well. Where's the comments at? Don't tell me. Of course, right? Bullet 3 in notes. Can the president be asked for stuff directly from his agencies? Okay. Marshall simultaneously recognized, however, that existence of a privilege to withhold certain official papers. So the subpoena, because that's just what they're just gonna argue, and I think isn't that what Trump did? No, well, I think he might have did something with that, but all right, I could be subpoena, but I could just exercise. I could just say privilege, and then you can't get them. And when a subpoena issued to President Richard Nixon, the court rejected his claim of absolute privilege. But recognizing the public interest in candid, objective, and even blunt or harsh opinions in presidential decision-making, it held that a presumptive privilege protects the presidential communications. Presumptive, okay. That's all right. Because that privilege relates to the effective discharge of a president's powers. The court deemed it fundamental to the operation of government and inextricably. How do you pronounce that? How do you even pronounce that? I know what it means, right? It means that it can't be pulled, can't be taken away in a way that is impossible to disentangle or separate. Yeah.
Inextricably.
Inextricably. Okay.
Inextricably.
Inextricably rooted in the separation of powers under the Constitution, criminally prosecuting a president for official conduct undoubtedly poses a far greater threat of intrusion on the authority and functions of the executive branch than simply seeking evidence in his possession. The danger is greater than what led the court to recognize absolute presidential immunity from civil damages liability, that the president would be chilled from taking the bold and unhesitating action required of an independent executive. And that's again referring back to Fitzgerald, but that's the civil stuff. Although the president might be exposed to fewer criminal prosecutions than civil damages suits, the threat of trial, judgment, and imprisonment is a far greater deterrent and plainly more likely to distort presidential decision making than the potential payment of civil damages. The hesitation to execute the duties of his office. You know, I wonder if that was actually, now that I think about it, I wonder if that sentence right there, right? The threat of trial, judgment, and imprisonment is a far greater deterrent and plainly more likely to distort presidential decision making than the potential payment of civil damages. I wonder if that's like a potential reference to Trump's like thing with like the lady, right? The lady that he was found civilly liable for for whatever he did to that woman, right? So I wonder if Because I wonder if the claim, we might have to look back at the case, right? But, right, because those things were done before presidency, before he was president, right? I think. Or was it in response to what he was saying while he was president? I don't know, bro. This whole thing is Gene Carroll, right? The Gene Carroll, right? Was it first? I know, like, the thing he did was obviously before he was president, but wasn't the lawsuit for, like, the things he said while he was president of the United States? So wouldn't that have? Yeah, I know it happened that's what I'm saying. Like, I know, oh, Jesus Christ, I know it happened way before. But I think the suit, but I think, like, the damages came about, like, when he says something about it while president of the United States. I could be wrong about that, but I wonder if this phrasing right here was to, like, kind of like preempt that the president can still be held civilly liable, even if it's for like certain things that might blend into his presidency. I don't know. I think he made a comment. Yeah, that's what I'm saying. Like, that it's starting to come back to me, like, a little bit. I'm pretty sure it was that, like, he said something while he was president. And so it's not very clear right now. It's not very clear if this had happened before that comment, would he have been immune from it? Right? Because he's allowed to give speeches. He's allowed to answer questions directly to the public. The public could ask him about it. So I don't know. This shit's crazy. This is crazy. Oh, hold on. I need to kill that real quick. God, where is it at? Stop it. Hold on. Yeah, here we go. Let me get you. I need. No. Oh, cool. I'll go right here, right? Hold on. Replay. There we go. Let me turn that timer off and close that. Disable. Okay, yeah, here we go. We're good. So that way that doesn't pop up no more. All right, let's get back to it. We'll open that back up. But yeah, it's not clear anymore necessarily if he would have been immune from being, like, sued, not after this ruling. But then again, the way they kind of posed this makes me think that they probably would have still been able to stick him with it. So we'll see. Although the president, and then of course it did happen while he was not president, but it would have stemmed for something that he did while he was president. And so, see, this reheightens my question, right? It's just that knock-on effect from anything the president already did, right? Which is something I'm going to write down, right? So this is another question, right? Do things stemming from a presidential act that happened after the presidency still enjoy immunity? All right. That's going to be a really good, important question for sure. Let's see. Okay. The hesitation to execute the duties of his office fearlessly and fairly that might result when a president is making decisions under a pall of potential prosecution raises unique risks to the effective functioning of government, but there is also a compelling public interest in fair and effective law enforcement. Taking into account these competing considerations, the court concludes that the separation of powers principles oh God, how do you explicate it? Explicate it? Is that how you say it? Explicate it. Explicate it. Is that
Explicate.
explicated then is how you say it, right?
Explicate.
Explicated. Okay, explicated. Analyze and develop in detail. Power principles explicated in the court's president necessitates at least a presumptive immunity from criminal prosecution for a president's acts within the outer perimeters of his official responsibility. And see, this is going back to criminal prosecution, right? So I wonder, I think this might have some type of knock-on effect for civil stuff then. It could. It's not directly stated, but it's probably the case. What popped up? It was Sneasel. Okay. Such an immunity is required to safeguard the independence and effective functioning of the executive. And actually, let me disable that since it doesn't work anyway. Oh, actually, it probably could still work. What I just need to do, I do want to just at least test that. Hold on. Let me just, I want to pull it up right here. I'm gonna click on this, and what I do want to do, let me mute that so that that's not loud. I'm gonna go into the chat here, and oh yeah, because like the runaway message doesn't even pop up, so there's no even telling what the hell this shit's doing. Okay. Can I just pop out this chat? Can I pop out the chat? Pop out chat. Yes, I can. Nice. And then I can close this. And all right, now let's just get back to it. That way when it pops up again, I can test it out. Okay, let's get back to it. Such an immunity is required to safeguard the independence and effective functioning of the executive branch and to enable the president to carry out his constitutional duties without undue caution. At a minimum, the president must be immune from prosecution for an official act unless the government can show that applying a criminal prohibition to that act will pose no dangers of intrusion. So here's the kicker right here. Here's the kicker right here that is probably impossible to actually overcome. So let's go here. What does this button do? Underline text. Strike through text. Strike through and add a note to replace text. Add a sticky note. I don't like sticky notes. We'll just leave it here. Okay, so this is the bar that is needed to be overcome. Overcome? Is it overcome? Is it? I guess maybe that needed to be overcome in order to prosecute a president. For sure. Okay. Dangers of intrusions. So what they're basically saying here is that if you're going to prosecute the president for something that he is empowered to do, you have to prove that doing so could not be portrayed as an encroachment onto his ability to do his job. So, which is crazy that they would even like say this in this manner, right? Because obviously if you're being prosecuted for something that you did in carrying out your job, being prosecuted for it would mean that you wouldn't be able to carry out your job in doing the said thing, is how I kind of like initially interpret that. So like this this is almost like a fake, restriction almost, right? Because like this would be, I can't think of at the top of my head an example that you could actually meet this. I just can't. I really cannot. Yeah, I really cannot. Like maybe like some, if I go back to like the civil liability thing, if I go back to the civil liability thing, maybe like, making comments about, no, that still wouldn't matter, because then like, even though you can't distinguish between like a certain topic. So if you could say like you can prosecute him for talking about something for a particular topic, you can't necessarily differentiate that from talking about another different type of topic that would be more serious or relevant to the nature or like the well-being of the United States. So in prosecuting that topic, you're showing that you could potentially prosecute the other one, and that probably wouldn't fly. So I really don't know. Actually, I just don't know. I don't know how you possibly overcome this. I'd have to look at examples, because I'm not a lawyer. So like, maybe somebody can like come through with like some really good examples of how you could possibly overcome this. As a president's unofficial acts, there is no immunity. Although presidential immunity is required for official actions to ensure that the president's decision-making is not distorted by the threat of future litigation stemming from those actions, that concern does not support immunity for unofficial conduct. I think that's the one thing that a lot of people were like complaining about, because I think throughout this document they never give you an examples or anything of like what an unofficial conduct would be. I think one of the judges do like talk about or give an example or something like that, but it's not actually what's the word I'm looking for? It's not something that's actually supported by the actual entire court. So it's not even necessarily clear if even though like the judge kind of laid it out, if you can even refer to that, because that would just be a dissenting judge saying they disagree and then for these reasons. But the court itself does not actually make that determination. I think, if I understand that correctly, we're doing a lot of like assumptions here because we do not have any of the background or expertise for this kind of stuff here. So let's see. The Clinton, blah, blah, blah. The separation of powers does not bar a prosecution predicated on the president's unofficial acts. Page 15. The first step in deciding whether a former president is entitled to immunity from a particular prosecution is to distinguish his official from unofficial actions. In this case, no court thus far has drawn that distinction. In general, or with respect to the conduct alleged in particular, it is therefore incumbent upon the court to be mindful that it is a court of final review and not first view. I wonder if this means, where are my notes? Come back, notes. Firefox. Oh, over here. I'm tripping. Okay, so what page is this? This is page 4. All right. Yeah, so page 4. So page 4 is where I actually want to make a separate page 4. I really have to clean this up, Adam. Page 4 lays out the steps for determining. It seems like this is about to tell me like how to make the determination of like whether he's immune from something. Yeah, and for determining immunity, and then we can bullet. We will bullet this list here. Okay. First step, let me read it one more time so I can make sure I understand, right? The first step in deciding whether a former president is entitled to immunity from a particular prosecution is to, let's see. Step 1, distinguish maybe I could just copy, right? Distinguish his official from unofficial actions. Well, no shit. Distinguish his official from unofficial actions. That's the first step. In this case, no court thus far has drawn that distinction in general or with respect to the conduct alleged in particular. It is therefore incumbent upon the court to be mindful that it is a court of final review and not first review. So when they say that, right? Okay, so a court of final review, not first review, obviously means that, oh my god, come on, F review should mean that these questions must be asked and hashed out first before the Supreme Court, because I think when they say this court, I think they're referring to the Supreme Court and not necessarily the court. It's the court system itself, right? Before the Supreme Court can make a ruling on the matter, right? So then obviously, so that means like every single thing is going to have to go right back through the court system from the beginning. Okay, so therefore all questions before the court should be kicked back down to the lower courts, right? Because that's, now that they provided new guidance, they need to actually kick it back down so those questions can be asked. Yes, okay. Critical threshold issues in this case are how to differentiate between a president's official and unofficial actions and how to do so with respect to the indictment's extensive and detailed allegations covering a broad range of conduct. The court offers guidance on those issues. Page 16 through 32. Actually, let me move down some, right? Let's see. ranges of pages that cover certain things, right? And so, okay. The separation powers does not bar a prosecution. Does not bar a prosecution predicated. Yeah. Okay. So we know. Okay. So page 16 through 32, right? Goes over guidance for determining the difference between official and unofficial and unofficial. What did I miss? Oh, I missed the I. Unofficial acts. Okay, so we got that there. When a president acts pursuant to constitutional and straight. Oh no. Hold on. You know what we need to do? Actually, we do need to hopefully Restream lets me do this. I do want to update the title here. Reading the Supreme Court decision on presidential immunity. I'm just updating the title. This should do it for all the platforms, hopefully. And I need to get rid of that R. Jeez, man. My keyboard skills are just so trash. Jesus Christ, man. Presidential immunity. Let's update them all. Boom. And so now if I refresh this, does it? Yep. That looks good. And then I can just now go to, let me just make sure, right? I think, come on. Let's see. Where's the button? Okay, cool. YouTube did it, Twitch did it. I think the only one that I actually have to still change myself is Kick. They slowly integrating stuff with Kick, but just not quite. So let's do this. Reading the Supreme Court decision on presidential immunity. Boom. All right. Now let me close it. Close. And yeah. And I guess I can stay open. All right, cool. All right. When a presidential acts pursuant to Constitution and statutory authority, he takes official action to perform the functions of his office. Right? Constitutional and statutory authority. I need to look this up real quick. Statutory authority. So would that actually be the laws then passed through Congress, right? Statutory authority refers to the powers and duties assigned to a government official agency through a law passed by Congress or a state legislator. I was right. Okay. He takes official action to perform the functions of his office. Determining whether an action is covered by immunity thus begins with assessing the president's authority to take that action, but the breadth of the president's discretionary responsibilities under the Constitution and laws of the United States frequently makes it difficult to determine which of his innumerable functions encompassed a particular action. The immunity the court has recognized therefore extends to the outer perimeter of the president's official responsibilities. Oh my God, this sounds so bad, bro. This is basically saying that because like you can't, because because it's so like hard to separate. It's so hard to separate the two. We're just going to assume that he also has immunity for all those things outside of it as well. Jesus, that sounds so. That's what I'm reading, right? Determining whether an action is covered by immunity thus begins with assessing the president's authority to take that action, but the breadth of the president's discretionary responsibilities under the Constitution and laws of the United States frequently makes it difficult to determine which of his innumerable functions encompassed a particular action. So they're basically saying because the president has all these different things that can like authorize him to do something, when he does do something, because there's like a whole host of different things that he could possibly be doing it under, as far as his authority to do so. We're going to assume, it sounds like this is granting the assumption of immunity, right? The immunity the court recognized therefore extends to the outer perimeter, right? So like giving a speech, because giving a speech isn't explicitly said or outlined in the Constitution or law or something like that, it does obviously extend for something obvious, like the president's requirement to, like, for example, give like the State of the Union address, or to answer questions from like the public. I think like when with the White House press briefings or something like that, where he has a chance to actually communicate directly to the to the people, then you can say that those things would be presumptively immune. That's what that sounds like. Let's see. The immunity. Oh, it happened. Hold on. Let me see. Let me see if it works. Does it at least work on YouTube? It does not. Okay. I gotta fix it. I'm going to highlight this. Under the Constitution, laws of the United States frequently makes it difficult for particular action right here. I'm going to highlight this. And so, right, this is derived actions would be considered outer perimeter actions, therefore granted immunity, right? And this is what is this? This is page, still under page 4. Still under page 4. Page 4, right? Outer perimeter would be, well, what am I doing? Why don't I just, I just want to copy. Yeah. I'm tripping there. Paste. Ain't no way. Can I copy? No, I know you saw me press the button. There we go. Derived actions would be considered outer perimeter actions, therefore granted immunity. All right, that's what I read there. The immunity of the court. Okay, yeah, that's what we read. Okay, so let's see. The immunity of the court has recognized, therefore extends to the outer perimeter of the president's official responsibilities, covering actions so long as they are not manifestly or palpably beyond his authority. So long as they are not his authority. So long as they are not manifestly palpably beyond his authority. You know something? I wonder then. So hold on. I think this might actually be important here, because then even though it wasn't officially supported by the entire court, but one of the justices did make that point about like his elector scheme. So this could be what makes the elector scheme exempt. Right? Because like he has, what did the justice say that I remember like reading or about that? She said that he doesn't, obviously the president has no authority for determining what the electors on behalf of the states are the one that do it. So then therefore this obviously, like his actions, whatever type of immunity claim he would try to possibly pull, like that inaction is the inaction that I think would be seen as beyond his authority. Therefore, he couldn't possibly be immune. So I think this part right here is probably going to be really important for that. That is actually, that's actually a really good find. That did not, if I'm reading it right, I could be totally wrong about everything I'm saying, but that's like, we're doing our best here. So therefore his elector scheme is almost certainly beyond his authority, since the electors are state determined. Okay, so I think that one charge, then, at least for that particular charge, that one might actually be safe and good. So okay, so we're good there. Let's see. In dividing official from unofficial conduct, courts may not inquire into. Oh yeah, this is what everybody kept talking about. This right here. This is terrible. Can I change the color on this? Can I change the color on this highlight? Customize comment tools. Highlight. Tools to show in toolbar. I cannot. Change color. Change color. Can I change the color? There has got to be. Hold on. Hold on. We got to figure that out. Hold on. There has got to be. There's most certainly got to be a way to change the color, right? Use drawing tool. Drawing tools. You mentioned earlier you think that the Supreme Court has been easy on Trump. The Supreme Court, I don't think so. Well, like the Supreme Court, I think the only thing that's been easy has maybe been his documents case. Like the Florida documents judge has been like pretty easy on Trump from what I've been hearing. But I honestly have not really been digging into the weeds of exactly what actions that they have been taking. So this is only just the stuff I'm hearing offhand, which can easily be construed one way or the other. But I don't know if you mentioned this. Yeah, I at least I don't remember. Maybe, but I think what isn't this would be the very first. I think isn't this like the very first thing the Supreme Court has like ruled over like in regards to like Trump. I can't think of anything else. I don't think there's anything else. I think like other stuff has made its way through the court system, but then like but didn't like make its way to the Supreme Court. I think this is like the very first one. Or the only one, right? Because even like when Jack Smith wanted them to determine the immunity thing, they rejected it and told them that it had to go through like the whole court process first before it reaches to the Supreme Court. So yeah, I don't think anything actually hit the Supreme. I think this is literally the very first Trump related thing that hit the Supreme Court. I think I don't pay too much that close attention to like all of the court stuff that happens, but I think that's probably the case. We need different colors. I certainly need different colors. So hold on, because this is a killer right here, right? Can't inquire into the president motives is a hell of a killer. Oh wait, can I put this up? Tools to show in toolbar. Add divider to toolbar. Can I hit? If I hit save. Oh, there we go. And I removed all my tools. And I don't think I can get them back. Okay, here we go. Jeez. Okay. Well, this is cool, right? Because then I could just take only what I need then. Okay, fine. So can you move this? Bro, why is Acrobat so damn difficult? Text, no stamps, attach file, record audio. That's cool. Replace text, strike through. You know what I should do? I should replace every word. Whenever they say president in this document, I should just replace it with the word king. That's... Why not? We're going to do that in a second. I'm just curious if it works. Text box, line, oval, blah, blah, blah. Drawer. Do I need a drawer? No. I think this is good for right now. I think that's really the only tools I really need. President. Let me get a word of the president. Hold on. Okay, let's close this. I must see this in action. President. Can I go like this? President. Oh, it's not going to actually edit. I thought I was going to do it. Add a note to replace text. I can't just... Won't just let me do it off the bat? We have got to do it. Edit text, right? Edit. Is there a function that lets you replace, right? There is a function. Control Shift H. It's got to be more. Nope. Guess I can't do it. Oh, I lucked out this time because I don't feel like digging too much time into it because it's petty. I think it'd be petty, but it certainly would be funny for me if I knew how to do it. Because I would sure change every word that they say president would be therefore changed to the word king. And it doesn't look like. Damn. So close. I was so close. Would have been funny. Okay, let's actually get back to it. Such a highly intrusive, but oh yeah. It made me forget what I was even talking about. No court can ask or look into anything that asks the question about something the president did, specifically his motives. So I guess so that's probably all communications, right? All communications of any form, right? How do you determine? That's actually a quick Google search. The different ways you can determine motive. As you can see, of course, the different ways the court can determine motive. Purpose and motives. The court can determine motive by looking. Let's see what it says here. What is this? Institute for Justice. Trump v. Dushbrand. Trump v. Oh wait, so other Trump court cases have been hitting the Supreme Court? I ain't never heard any of these. Each case concerns subpoenas issued by 3 House committees seeking information about Donald Trump in his personal capacity, along with information about his companies and his family members. Oh, I think I might remember this, maybe. But the committees did not request information directly. Instead, they subpoenaed 2 banks and an accounting firm. Okay, I remember this. Yeah, I was gonna say I don't remember it being like the president directly. I thought it was just like stuff the president had. Right, because this was related to the IRS tax stuff, right? Because wasn't it this whole thing because he ain't paid taxes in like 10, 15, 20 years, and he did so like legally because of like he was able to exploit stuff, so they was trying to get the documents to see how exactly he was doing that so that they could make the laws to like kind of patch that loophole, I think is what that was about. The President Trump intervened in his personal capacity, seeking to squash the subpoenas, arguing that each case was beyond the powers of the House committees to issue. Okay, I do remember this. Trump and associates lost both cases in the Second Circuit and in the DC Circuit, and now their fate rests in the hands of the 9 Supreme Court justices after Tuesday's oral arguments. But to paraphrase Justice Breyer, the issue of these cases go way, way, way beyond just tax returns. The key question in both cases is whether the House committee had the powers to subpoena the requested documents. The question turns in part on how the court looks at purpose and motive. The Supreme Court has held that Congress has broad investigatory powers to obtain the necessary information to aid in its exercise of the Article 1 legislative powers. Part of those investigative powers include the power to issue subpoenas to obtain relevant information. But that power is not unlimited. The Supreme Court explained that this investigatory power should not be confused with law enforcement powers. This investigatory power is limited. You're right. I could be botching that word. I could still be botching that word. Is that
investigatory?
Investigatory. Oh, okay. I guess it is. That is how it's said.
Investigatory.
Okay, investigatory power is limited to only those areas over which Congress has the power to legislate. That is, for a legislative subpoena to be valid, the subpoenas must serve a valid legislative purpose. Huh? You know that than anything, right? Wouldn't that mean that anything that Congress could subpoena would be legitimate, right? Because Congress can pass a law for just about anything, isn't it? Like, isn't that the case? They can outlaw stuff. They can make things legal, right? They can create holidays. They can create That's actually a really interesting statement there. So I I wonder what court case is this again? This is between these two, right? Trump v. Deschbank and Trump v. Myers, right? Because these are both court cases. Let me go here real quick, and this is still page 4, right? Jesus Christ, man. According to court cases and Trump v. Oh, does it already have the links to those? Does it? Or is that? Oh no, it's just. Or is that just the links to the actual court cases? Oh, it is. I should probably grab this too. And let me go ahead because I like to have my notes all together here. Okay, according to the court cases, Myers, right? Congress should have the power to subpoena, right? I knew I was going to spell that wrong. To subpoena anything for which they have, how do they say it? The authority to legislate, right? Areas for which Congress has the power to legislate. Subpoena anything for which they have the power to legislate. To me, that sounds like that's a really broad power, isn't it? Because like they can literally legislate anything. Law enforcement, right? They can create agencies. And I'm writing this down because what's the conflict that then arises? As a matter of fact, they could grant the president power. They could grant the president power to be able to do stuff, right? That gives him his immunity. So I really do think I really do think that this means that he's just immune from just the regular court system. But Congress can still come in for anything, but Congress is not a criminal. It's not a criminal like prosecutory body. Do you think that adds leverage? When you say add leverage, what do you mean exactly? Like leverage for Congress to pull levers on the president for certain things, right? Because I think that Congress inherently, Congress already inherently had a lot of a lot of like checking power over the president and his actions. I mean, those are like kind of hard coded into Congress. Yeah. Those are already like pretty hard coded into Congress, like, you know, the power of the purse. What is this, a caterpie? Okay. The power of the purse, the like, what is it, like, you know, as far as like authorize and continue like military actions, and then of course like everything, the whole impeachment process, right? So I'm just wondering if there's any new conflicts now that could potentially arise between this immunity conduct and what's the word I'm looking for? Yeah, and this immunity conduct, and then like what Congress can sit there and do. Because if I'm not mistaken, like Congress can still do like really specific criminal things, like contempt in Congress, right? When Congress asks you to show up and you choose not to show up, like you can, like they can hold a contempt hearing, and then they can find you guilty, and then like you can actually get jail time and whatnot from it. So I'm just curious, like under that specific circumstance, right? Like would the president be immune or not? Because like it's a congressional power. It's a checking power that Congress, I don't know if it's a direct checking power on the president, so that could probably matter. But I don't know, this my brain hurts. My brain really hurts because there's so much. There's so much unasked questions now with this new court, with this new decision from the Supreme Court, that so much stuff is just up in the air. What's the conflict that then arises between Congress and the executive branch when it comes to things in the judicial sense? I'll say in the judicial sense. Can Congress compel the president for a hearing? Can Congress compel the president for a hearing? That's gonna be a really good question to ask. Okay. Such a highly intrusive inquiry would risk exposing even the most obvious instances of... Oh, let me make sure I wrote this down, right? According to the court case... Oh yeah, I didn't. I knew it. I do want to write this down. Go like that. Bam. No court can ask and look into anything that asks the question about something the president did, specifically his motives, so that's probably all communications of any form. Yeah. Cool. Okay. Such a highly intrusive inquiry would risk exposing even the most obvious instances of official conduct to judicial examination on the mere allegation of improper purpose. I'm thinking the mere allegation of improper purpose. So then who would determine improper purpose then? I mean, I'm so confused about this. Who determines improper purpose then? Isn't it the court's job to actually determine whether something was like... I'm pretty sure. I'm trying to think. I'm pretty sure it's the court's job to determine if something was improper or not, right? If you break the law, I need to determine, it's the court's job to determine if you actually broke the law or not, right? If your actions, your conduct was improper when stacked against written text in a law or statute. So, what the hell? Who determines improper purpose then? Actually, I want that whole section here. What the damn? Let's have page 4 here, right? Who determines improper purpose? Okay, nor may courts deem an action unofficial merely because it allegedly violates a generally applicable law. Oh, so this is okay. Now that we're actually reading this document, this is the stuff that they were really, I gotta sit up. Really going crazy over here. Wow, this is crazy. Nor may courts. Oh, sorry. No. Oh, wait, can I? Oh, is this? Now we can do it? So that's what I needed to do? Brev. That's how we do it. Okay. Now we got our colors, right? Because I really needed that. And I forgot about it too. See, I was doing all that for the colors, and then I totally forgot because I got distracted with trying to change the word president with king. Let's see. We'll figure it out. Off stream, we're going to figure it out. I promise. Let's see here. Let's see. I have to read this again because I don't even know what to make out of this. Nor may courts deem an action unofficial merely because it allegedly violates. Wait, the way I read this though, I think they're saying it'll be a weird thing to say, but I guess they're saying that the court can say an action was unofficial for an allegation that hasn't been, I guess, tested first. Maybe that's what I'm reading. I think that's what I'm reading, right? The court cannot say an action was unofficial because of an allegation that it violated a law. But I like that it says an allegation that it violated a law. So I wonder then if it gets proven that it definitely violated a law, could this be a loophole? This might actually be a loop. It could potentially be a loophole where it's like, okay, well, they say allegedly violated. It's not alleged anymore, right? It went through the trial system, and it was determined that it indeed violated the law. So we can say that this official act is no longer can be seen as official, right? I think that's what I would have like gotten out of this. And let me fix that. And let's go here. Okay. The court cannot say an action was unofficial because of an allegation that violate the law. And let me potential loophole maybe. Okay, otherwise presidents would be subject to trial on every allegation that an action was unlawful, depriving immunity of its intended effect. Although then the question is that how would you even get to that? How do you get to Control Z? I was about to say Control Z better work. How would you actually get to that point of actually determining would be the next question of it. Because this sounds like they're not even going to let it like go through the court system at all. Let's see. Total impunity. Yeah. That's just, I mean, that is what it is, right? And like you can't even go through the steps of even trying to like hash it out if it's even like a violation of the law, because like he's just assumed immune. This shit crazy. This is very crazy. Okay, so let's keep going, right? With the above principles in mind, the court turns to the conduct alleged in the indictment. Certain allegations, such as those involving Trump's discussions with the acting attorney general, are readily categorized in light of the nature of the president's official relationship to the office held by that individual. Right? So here's the thing here, right? Because the president is empowered through the Constitution for control over his officers and communications and whatnot. Therefore, if there's any, so this is actually would refer to earlier about like you can't even inquire into his motives or whatnot. So that would mean that the question, because we totally got distracted when trying to read the other thing, right? The question about trying to determine the motive, because I think the only way you can determine a motive is if you have information about the things he might have said in the past. Any directions he might have given, all of that is off the table now. And I think, I'm not a lawyer, I don't know, I think those are the only ways you can really reliably determine the motive of somebody, right? Because people oftentimes get motive and Jesus, I can't even think of the word. There's like there's another thing that's really close to the word motive, but it's different, that people tend to like get confused when you're trying to like determine criminal conduct. There's motive and then there's intent. There we go, intent, right? Motive and intent are actually two completely different things. I think I remember hearing somebody give the example of like robbing a bank, right? Because like if I showed up into the bank with a gun and I told somebody to give me the money, right? Then there you go, right? You now have my intent, but you don't necessarily have my motive. My motive could be something completely different. Am I robbing the bank because I'm poor? Am I robbing the bank because I'm trying to make myself look out to be, some kind of like public figure that can just go rob banks, so those things are different. And so like the motive, I think you could only rely on like just like statements. I think that's the only way you can really determine motive. I'm not entirely sure. So we actually need to finish reading this. Okay. But that power is not unlimited. The Supreme Court has explained. Let's see. The Supreme Court has explained that this investigatory power should not be confused with law enforcement powers. Okay, we read that. How do we know if a subpoena serves a valid legislative purpose? Okay, I know that. I want to know how you determine motive. Questioning the government's motives. Here we go. The issue of motive comes up in many of. Oh, this thing. What do they call this thing? The Institute for Justice. Of Institute of Justice Economic Liberty cases, we often argue that the announced health and safety purpose of many economic regulations is nothing but pretextual, and that the real reason or motive is protectionism or handing out favors. For example, New Jersey bans bakers from selling cookies, cakes, and muffins that were made in a home kitchen. The announced purpose for this is health and safety, but the state simultaneously allows people to bake these same goods in a home kitchen and be sold for charity or a non-profit bake sale. Oh, that is actually a very interesting distinguishment. I wonder why they, yeah, okay. I wonder why they would like make that like you can't sell it officially, but you can do it if you're trying to raise money. You can't. I guess it would depend on the argument you're trying to make, but okay, whatever. We argue that this exemption shows that New Jersey's real reason is its motive for banning the sale of home kitchen is protectionism. It's probably for business, right? To keep businesses, that the actual bakeries and whatnot, from going out of business is what that sounds like. That is, if you measure the announced purpose against the actual law, you can find the actual motive for this restriction: protecting commercial bakers from competition. Yeah, see, I was right. We can see how this works in another IJ case, excuse me, that was recently before the Georgia Supreme Court. There, the state in 2018 began requiring all lactation consultants to obtain a certification. What the hell is a lactation consultant? Are you talking about like milk production, like from cows? Or are you talking about milk production from something else? What are we bursting? Okay, I was right. I thought. Oh my God. How do you consult somebody to breastfeed? Isn't that just doctors? Is this something that require doctors to do? Or is this like, can I actually just be a consultant for mothers on breastfeeding? That's kind of wild if that's the case. I would read into it more, but we just don't have the time. And let me go back. Stop it. Breastfeeding. I knew it. It is a breastfeeding thing. Cow milk is for baby cows. Cow milk is for baby cows, but this sounds like this is actual lactating breastfeeding battle. Yeah. So this is actually talking about Jesus Christ. Yeah. This is talking about just women just breastfeeding children. You can be a consultant that specializes in like telling women how to breastfeed babies, I guess. I don't know. But okay, it's getting cold, man. The exemption to question whether the announced purpose. Oh, wait, I am going back. Okay. Georgia did this under the guise of protecting new mothers' health and safety, but Georgia exempted any lactation. I know, right? But Georgia exempted any lactation consultant who did not charge for their services. Exempted any lactation consultant who did not charge for the services. So you can consult the mother on how to breastfeed her children without a license if you're not going to charge for the service. Otherwise, if you're going to charge for the service, you must be licensed. I would love to know how the training, what's the certification process for being certified into something like that? That is crazy. Some justices on the Georgia Supreme Court picked up on his during oral arguments and used the exemption to question whether the announced purpose was the real reason for the regulation. Again, the motive is important and can be found by measuring the law against the announced purpose. We at the Center of Judicial Engagement have long advocated that government must have both constitutional ends and constitutional means. That is, the government has an unconstitutional reason for doing something, then even if the specific action is constitutional, the bad motive renders that action unconstitutional. Yes, we know this, right? You present it as one way and then you use it to do something else, right? That can be a problem. Yet courts sometimes fear looking into motives. There is concern that looking into motives requires depositions or the scoring of committee reports to find the real reason why Congress has passed the particular law or issued particular subpoena. I don't even have to finish reading this. So this all just tells me that indeed, right, you have to have some type of, so it does. It requires some type of statement, some type of writing, and all that's now officially off the table. So like, if you cannot look at any of those things, you can't determine motive. And so like the Supreme Court definitely just took that off the table. I'm gonna take a quick browse. Motive. Let's see. Motives. A motive is the cause that moves people to induce a certain action. In criminal law, motive in itself is not an element of any given crime. However, the legal system typically allows motive to be proven to make plausible the accused reasons for committing a crime, at least when those motives may be obscure or hard to identify with. However, a motive is not required to reach a verdict. Motives also used in other aspects. The law technically distinguishes between motive and intent. Yeah, so this is what I was saying about the difference between motive and intent. I get that, but how do you? Yeah, it seems like to me motive's role in criminal punishment. Motive plays. Oh Jesus, I'm not about to read all this. Not right now, but this is, bro. Why can't I just get a bullet point? You can look at this, you can look at that, or you can do this and finding it. Jesus Christ, can be proven by the admission of evidence. For example, okay, here we go. This should be short and sweet to it. In the legal context, what is this? This is a corphish. I don't even know what the hell that is. That catch command doesn't work, by the way. Okay, I haven't had a chance to just turn it off because I gotta play around with it and figure out why it's not working. A motive can be useful in combination, blah, blah, blah. For example, here we go. Missouri case of State v. Friend. Clarence Friend was convicted of first-degree assault after engaging in a high-speed vehicular. Ah, God, that is... I gotta hear it. I gotta hear it to know how to say it right. Bro, if you don't... Block, okay? I don't know why you was in my way. Vehicular consultants. We got consultants for everything in the U.S. Jesus Christ.
Vehicular.
Vehicular. Ugh, that sounds like a harbor word. Chase with a police officer firing a handgun at the officer and fleeing. A passenger in the defendant's car claimed the driver's name was Donnie, but officer concluded this was false and instead arrested and charged Friend. At trial, Friend denied committing the crime and the passenger refused to testify, invoking the Fifth Amendment's protection against self-incrimination. Among other, well, yeah, actually, because you're in the car with him, so I guess this will apply. Among other evidence, the prosecution introduced evidence that Friend had escaped from a halfway house, was involved in the burglary of a liquor store, and had a warrant out for his arrest. This was put forth as proof of Friend's motive in fleeing from and shooting at the police officer. Okay, so not just statements, but actions. I think I remember reading about this, that somebody said about this in the Supreme Court case, right? So you can look towards public statements or any public information in determining motive. Because I think somebody gave the example about accepting a bribe, right? Because if somebody offered the president a bribe for, I think the example was offer the president a bribe for a pardon, and then the president pardons, right? Because the bribe is technically illegal. You can't question or bring in the evidence, the conversation, or anything about being bribed, because him being able to pardon or granting the pardon, because the pardoning is an official president duty, therefore it would be exempt and immune from being questioned at period. But you could potentially use the pardon once it hits public records to show. Is that how I read that right? I don't know. Like, this stuff gets so confusing after a while. But I'm pretty sure that's how it was. You can't question the pardoning, but you can't question the pardoning because it's an official president act, but you can question the bride, right? Which he bribed the president with money in order to grant the pardoning, but you can't question the pardoning. But you can then question it, I guess, once it hit public records. It's a very, very weird, convoluted, I guess, process for trying to hash that out, which I think once we get to the Supreme Court justice that actually gave that example, we'll have a better understanding. Because I only heard about it like once or maybe twice and couldn't really understand it. But okay, so motive, right? So we can use public records. So motive, the person's statement, or any written correspondence the person would have, those are off the table. But anything public that could show, that can reasonably give a terminating fact for why somebody did something, could still be used potentially. Okay, now let's actually get back to the document here. Other allegations. Was I here? Oh yeah. So with the above principle in mind, yeah, we read that. Certain allegations, read that. Other allegations, such as those involving Trump's interactions with the vice president, state officials, and certain private parties, and his comments to the general public, present a more difficult question. And that's because earlier they said that the anything shared with Congress. Well, I don't know about the state official. Well, okay, I guess I can see this. Well, no, the state officials doesn't have anything necessarily to do with Congress. So I think his communications with the state officials should probably be immune, but his communications with the vice president shouldn't be, because the vice president has constitutional, like, purpose for both the executive and the judicial and the legislative branch, right? Being president of the Senate while also being vice president of the United States. So at least that's how I interpret it. And they said 1930. The indictment alleges that as part of their conspiracy to overturn the legitimate results of the 2020 presidential election, Trump and his co-conspirators attempted to leverage the Justice Department's power and authority to convince certain states to replace their legitimate electors with Trump's fraudulent slates of electors. According to the indictment, Trump met with the acting attorney general and other senior Justice Department White House officials to discuss investigating purported election fraud and sending a letter from the department to those states regarding such fraud. The indictment further alleges that after the acting attorney general resisted Trump's request, Trump repeatedly threatened to replace him. The government does not dispute that the indictment's allegations regarding the Justice Department involves Trump's use of official power. The allegation, in fact, plainly implicate Trump's conclusive and pre-conclusive authority. The executive branch has exclusive authority and absolute discretion to decide which crimes to investigate and prosecute, including with respect to allegations of election crime. Nixon. And the president's management of the executive branch requires him to have unrestricted powers to remove the most important of his subordinates, such as the attorney general, in their most important duties. So without reading anything else, right? What they just basically said here is that we know a core power of the president is his ability to hire, and well, actually not necessarily hire, because I think that still has to go through Congress, but to, at the very least, fire whoever he wants in the executive branch. He wants anybody that is under his purview, he can fire regardless of what. So if he wants the Department of Justice to go after somebody like in an improper way for a crime, and they say not to do it, or they don't want to do it because it's improper and they think it's illegal, he can fire them, and that's it. That's the end of that story. There's no questioning. There's nothing that can be asked about it. Like, all of that is all within the president's power to do so. And so with that in mind, it sounds like to me then that any of those like specific details and any of those upcoming court cases with Trump over like whatever he did with the elector stuff, that stuff is about to get thrown out. I think the Georgia case is probably and I'm surprised nobody's even talking about this. I think this ruling just killed the Georgia case. Now that I think about it, right? Because the Georgia case about the whole fake elector scheme, but him trying to pressure the, I guess, whatever state head of Georgia to, I want you to find, what is it, like 1,100 or 1,300 vote, however many votes it is, because it'll be one more than what we currently have. And then once you do that, I'll take care of the rest, right? That's my not so good in trying to mimic Trump's voice here. I think that just literally got thrown out of the water. It can't go through the court system no more. I don't think that could go through the court system no more, right? Because his communications with state officials is official. It's official president duty. Him firing his attorney general for not wanting to do any of the stuff related to the fake electors. Dog, when I say if Trump gets back in the office, this shit's going to be crazy. Oh my God, this shit's about to be crazy. This shit's going to be crazy if he wins. If Trump wins back the White House, bro, this shit's going to be chaos. I'm just saying here, I'm monologuing, don't mind me. Getting back to this though, okay? So he can fire whoever he wants for any reason and it can't be questioned. So that we know this. Unrestricted power, yeah, so we know this. The indictment's allegations that the requested investigations were shams or proposed for an improper purpose do not divest the president of exclusive authority over the investigative or prosecutorial functions of the Justice Department and its officials. This right here, this is important right here. This is for sure important. What is this, page 5? Shit. I mean, can I go back to yellow, please? Delete and get back to being yellow, please. Come the hell on. Shit. Come on. That's actually super important. So now we're in the page 5. I just move this up here. I should move that up there and then move that down. I cover certain things. I'll give this a level 2 header, and I'll clean that up later. But we are now into page 5, right? Right, page 5. So now when I need to go back, I can just know what page to go to here. Can't I link? Can I link specific pages in this? We'll give that a quick look. Bullet. Testing link. I'm curious. Can I? It'd be really cool if I can do that. Let me go here. Come on. Copy link to block. No, I don't want that. Turn into. Bro, come on. Can I? Why am I drawing a blank on like how did I used to link shit? This button. Oh God, that was terrible. Is there a way? Can I actually? No, I don't think so. I think I'd have to probably find a way to like add it. I'll look into that later. It'd be really convenient if Notion lets me like insert PDF documents and then I can actually reference those pages directly. That'd be really nice because then I could just click on a link and take me straight to a page in Notion. Do you really think he can be president after all those charges? Yes, absolutely. Yes, he can still be president because there's nothing. My understanding, there's nothing in the Constitution that bars the president from barring anybody from being president. Besides, I think that one thing about having to have like, what is it? I'm drawing a blank on the word, but like the insurrection stuff. I think that's the only thing you can do to bar somebody from being president or holding office. But the Supreme Court already shot that down and said that only Congress can actually enforce that. And Congress is not about to enforce that. So as far as I know, he can be president. He's positioned to where like right now, just the slightest of disruption can easily go in his favor and make him president. And then once he's president, remember, he's the head of the executive. He's the head of the executive. So like all those charges and stuff he can have removed. All the federal stuff he can have removed. All of the state stuff, right? Because I think the only state thing he has, because New York thing is done. Although New York's that sentencing thing is going to be crazy. That sentencing thing is going to be another crazy thing. Let's look at that later. But the Georgia thing, because Georgia is still Republically controlled. Then like the governor is just a pardon him. That's what's about to happen. Hold on. I gotta swap the batteries in my heat up socks because my feet are getting cold here. Let's see. This terrible president, but very funny. His tweets and insults are so funny. Oh yeah. He can definitely be funny sometimes for sure. But yeah, no, like if he wins the presidency, the only thing, and that's what I was saying, like what I was really worried about, the only thing that could be like catastrophic is going to be New York. New York is the only one that could be like really catastrophic because if they give this man a jail sentence and it extends for a year plus, and then he wins the presidency, because I am not familiar with any mechanism in the federal government that could release him from prison, right? That is only state ran. I think only the governor has the authority, and if the governor was to sit there and be like, no, we're holding you in prison. My next question is, how does the Secret Service work? And then also, can he still give lawful commands in there, right? But like, how would he get those commands out of the prison? Because then could he just order? And then the thing is, he has this immunity now. So could he just order the military to break him out of New York prison? That would be, oh my God, bro. That, like, actual things that can really happen right now, bro. Could he order the military to, like, jack up New York and get him out of prison, right? Bro, oh my God, bro. I'm just sitting here thinking, like the amount of chaos would be unreal. That would most certainly then lead to a civil war, 1000%. If it was that, and the crazy thing is that we actually we're a stone toss away from certain actions happening from that becoming an actual reality. That could actually really happen, right? His sentencing's coming up. He goes to jail for a year plus, right? He wins the presidency. He's still in New York jail. He has immunity now, a very broad immunity. And it's already been posed that he can like order SEAL Team 6 to like, you know, assassinate people and it can't be questioned. I'm going to order the military to conduct a strike on New York and break me out of prison. Boom. Oh my God, bro. This is it's going to be crazy. Let me get back to this. This is going to be so crazy. So crazy, so crazy, so crazy, so crazy. All right, so we know our testing thing doesn't work no more. The indictment's allegation that the Chris investigations were shams. Right. So, okay, yeah. Allegations. Right. So allegations of improper purpose does not strip. Oh man, why is it in caps, you bastards? Allegations of improper purpose does not strip the action from being official, right? Does not divest the president of exclusive authority over the investigation and prosecute functions of the Justice Department. Yeah. So allegations of improper purpose does not strip the action from being. And they keep saying allegations. So I guess but it can't be questioned, because I keep on sitting here like allegations is different from like being a determinant. So like an allegations is just like it's alleged, and then like once you go through the process, then it's either determined or proven not to be the case. So it's like technically this opens up to like when something's determined to be the case. And you know why that keep coming up in my mind? Because I think could Congress like say something or pass something that would say this is like to make something a determinant, and because it's a determinant and not an allegation at that point for it, it's therefore not part of the purpose. I don't know. That's just me trying to just be creative and trying to find some type of balance to this. Hold on, let me just finish the sentence. Allegations of improper purpose does not strip the action from being authorized by the president, therefore an official act, right? So that's what that is. Did you ever wish you got a degree in political science? No. I love all my my political friends. This stuff, like diving super deep into politics or specializing like my life into politics, is so boring. I'm sorry, it's just so boring. For me, it is. Oh, cool. It's a Bulbasaur this time. I need to cut it off. I am about to cut it off. Let me just cut it off real quick. But I'm like I said, like my passion has always just been technology. So that's why, like, that little band animation thing, I had a lot of fun doing that band animation. Like I was literally up until like 7 in the morning, until like 7 in the morning trying to get that to work. Oh, did this shit freeze on me? Oh, it sure did. Can I refresh it and it connects back through? So like, anything tech related, I get an inherent pleasure out of, for sure. Hold on. I'm just go in and go to settings. I can actually show you what it looks like, right? So I'm connected to my other laptop here. And so this is the StreamerBot application. So I'm gonna go here, settings, and I'm going to go ahead and disable that and work on that later. But here's what I'm talking about like as far as actions go. So like that band animation thing, for example, right? There's the triggers, so the things that it's watching for to happen. And then what it does is then it executes all these things that I have to manually set. So I have to first set it up to connect to OBS and have OBS share information with it, which is not necessarily that hard. And then I can tell it to like make this thing visible, don't make this visible, blah, blah, blah. And then, right, the band thing specifically is actually to deal with a lot of code, or not a lot of code, but quite a bit of some coding magic here. So that I'm not gonna do the Pokemon one yet, but like so Among Us band. So like so for example, like the Among Us band, all it's doing is just making a browser source visible. So you have a web page that it'll make visible, and then in that web page has a JavaScript to set the name for like the person that's being banned, and then the actual the CSS code, which is what's doing all the animation, all of the colors and movement and stuff, is what actually does all the stuff you see as far as like the actual Among Us like animation, right? Not the card, not the trap card. The trap card thing was all specifically me, but the animation, bro. Why is my Sublime? Stop playing with me, Sublime. Wake up. The actual animation, right, was like already in this template, and then I would just edit it to make it all I did was just edit it to simply make the words a little bit bigger, which actually took some work because I had to look at both the code in this file, the CSS file, and index file, which I don't know how much coding experience you have, but like it's web languages. So just like every web page you go to, Google and whatnot has like HTML code, CSS code, JavaScript stuff, right? And if I can get the application to get up, god damn it, Jesus Christ, man, what the hell is it doing? Okay, it's playing with me. I'm getting mad now. I hate when technology just doesn't work for whatever strange reason. Okay, it's finally up because I was sure about to like destroy it digitally speaking. Okay, let me close that. Yeah, here we go, right? So see, like this is all like CSS code here, right? And a lot of this was already pre-done, and then I needed to figure out where to go in order to get to the text, because that text, how big it was so you can actually read it, wasn't originally like that. It was like the original Among Us small little print. I was like, I couldn't do it, but changing it here actually didn't work. I had to, or it didn't work directly yet. I had to come in here and actually figure out how it was being referenced, and then come here to then actually create it. So then I created this here, which is just like, see, it's just a little simple thing, right? Boom, done. Now for the actual trap card itself, yeah, I can close these because I don't even need it no more. I can close all of this actually. Yeah, we can close all of that and close this, and oh, I opened up another one. That's why I did that. Okay. For the actual trap card, the trap card is actually a video. And can I go up? Let me go up. Cool. So the trap card is me taking a bunch of different assets and actually making a video out of it. And that one I used a bunch of different applications. I used GIMP, right, to do the actual physical card artwork, right? Because I found a trap card. I did find like a blank trap card template, which I can show, right? So see, I found a blank trap card template, and then I had to actually find the proper fonts, right? And I used GIMP to do, the hell is this? Is that a random Chinese baby? It just pop up. Right. See, it threw me off because see, it just had a random Chinese kid just pop up on my thing. Hackers. But GIMP to make the editing for the actual artwork, right? Once I put all this stuff together, finding the proper fonts and everything. And then like all of the sound effects that I had to fish crazy on the internet for, right? Because I used a specific game, a specific Yu-Gi-Oh game in order to do the sound effects, and then finding the snippet of like that famous, like you activated my trap card sound. All that stuff is cool. But we getting distracted. I turned it off, right? I turned off the Pokemon thing. And then the Pokemon thing is hella complicated. Here's the Pokemon thing right here. Hold on. Catch Pokemon. 37 actions, right? Here's all the different things that go into that whole Pokemon thing that I gotta figure out. And it's a massive pain. It is a huge, massive pain. But we will figure it out another time. So let me go back here. Now let's get back into this court case. Okay, and then yeah, I feel like you'd be a good debater. I appreciate it. It's just so long as I'm just armed with like the proper facts, like as long as I just understand everything that's going on. I mean, if you're trying to argue something that's not coherent with what's factually being stated, then or like being derived in like a logical, conclusive manner based on the facts, then yeah, right. Then obviously, you're not making a very good argument. And that's what I tried to like stick to. That's also why I try to stay away from moral arguments, because moral arguments is just free falling, right? You can't adhere those to anything. So therefore, they're just a problem I just try to avoid. And hold on, how long have I been going for? Okay, only 3 hours, almost 3 hours. Cool. And it is now officially Sunday. Okay, because the president Cannot be prosecuted for conduct within his exclusive constitution. S. I love it. The word S. Is exclusive constitutional authority. Trump is absolutely immune from prosecution for the alleged conduct involving his discussion with Justice Department officials. Okay, so the stuff with the Justice Department stuff. So any references to that, yeah. So like I was saying, like any references to like the Justice Department stuff, Brav. Trump is absolutely immune from prosecution for alleged conduct involving his discussions with Justice Department officials. Okay. Actually, I do want this in red. And this is what I was talking about when it came to intent, because now, right, a big pillar for determining the intent motive is out of it. Oh, well, I guess you could say intent too, right? Because if he was intending to do something, he was communicating with somebody the intent to do something. Yeah, right. All that's out of the water. All that's most certainly out of the water now. The indictment next alleges that Trump and his co-conspirators attempted to enlist the vice president to use his ceremonial role. Now, this is what I want to know, because vice president stuff is going to be interesting to like get into. The vice president used his ceremonial role at the January 6th certification proceeding to fraudulently alter the election results. Let's see, blah, blah, blah. In particular, the indictment alleges several conversations in which Trump pressured the vice president to reject. Oh, no. Those conversations, let's see what they do with them. They're probably going to throw them away. Pressured the vice president to reject the state's legitimate electoral votes or send them back to state legislators for review. Whenever the president and vice president discuss their official responsibilities, they engage in official conduct, presiding over the January 6th certification proceeding at which members of Congress count the electoral votes is a constitutional and statutory duty of the vice president, right? First off, like, when is the vote certification? When is the 20 election certified? Election day marks the final day which voters can cast a ballot, but the electoral system chooses. I'm just curious, like, what day is that? Certification appointment no later than December 11th. Meeting and vote of electors in their states. So this is when the states do their thing. Deadline. So it is actually every January 6th. Okay, so every 6th of January. Okay, that's kind of good to know. I was just curious here. Okay, so where was that? The indictment alleged allegations that Trump attempted to pressure. Jesus, stop it. Go here. Turn it off. Cool. Okay. The indictment allegations that Trump attempted to pressure the vice president to take particular actions in connection with his role at the certification proceeding thus involve official conduct, and Trump is at least presumptively immune from prosecution for such conduct. I'm going to read this one more time. Let me start from here. Presiding over the January 6th certification proceeding at which members of Congress count the electoral votes is a constitutional. Let me close this here. I can't believe what I'm reading right now. Is that really about to be the case here? Ah, God, man. Proceeding in which members of Congress count the electoral votes is a constitutional and statutory duty of the vice president. Oh wait, is it still under Article 2? I would have thought that would have been under. That wouldn't have been under the. I don't know which article deals with what it precisely, but I would have thought that would have been under like with the legislative branch. Okay. The indictment's allegations that Trump attempted to pressure the vice president to take particular acts in connection with his role at the certification proceeding thus involved official conduct, and Trump is at least presumptively immune from prosecution of such conduct. This doesn't make any sense. Hold on. The indictment's allegations that Trump attempted to pressure the vice president to take particular acts in connection with his role, are they? I'd have to research this, right? Because I thought the vice president's role is tied to Congress and is not tied to the executive branch, right? If it's tied to Congress and not tied to the executive branch, then how could it possibly be immune if the conduct in which, like, the official communication could be immune, But because it's dealing with him doing something in Congress, how could that possibly be immune? I know it's presumptively immune, but attempted to pressure. Let me see. With this role certificate thus involve. What's the official conduct? The official conduct of what? The president has no official conduct when it comes to when it comes to Congress. He only has official conduct when it comes to just communicating with the vice president. See, this okay. This we're gonna mark this as I'm gonna mark this as green, not green. I'm gonna do it like a dark orange. All right. This is very this to me is really this noticeably okay. Cool. This is noticeably different from yellow. Okay. This is noticeably different from what my understanding of like the vice president's role. Because I guess it boils down to like, I guess what article or what clause empowers the vice president to do it. If it's empowered by I guess whatever article presides over the president's power, then that's how they would get away with that. But I was under the assumption that because it dealt with Congress, it had to been tied directly to the legislative branch. So not part of like the executive branch, and therefore it couldn't possibly be under the president's purview. So, okay, question. What empowers the vice president? The vice president, geez, come on, keyboard. President to preside. Oh my God, my keyboard refuses to allow me to live. The empowers the vice president to preside over. The vice president to preside over the Senate, right? Because isn't he president of the Senate? I think is what it was. Preside over the Senate, right? And that's because if it is somehow tied to the executive branch authorizations, then yes, everything related would be immune. Otherwise, this couldn't possibly be immune since it, right? Because since its parent would be outside the executive branch, right? The legislative, right? Because so far what we understand is that the president himself, and then therefore everything that the president has the authority to do, could be seen as immune, or at least like presumptively immune. And then they made clear that the stuff that's shared with Congress doesn't enjoy inherent immunity. So I thought at the very least then the vice president would at least share that kind of situation with both the executive or the legislative branch. But if his role and actions in Congress is strictly because of like whatever empowers like the presidential or the executive branch, then yeah, then that whole thing is hold, and they have to throw all of that away, because then the vice president is under full control of the which would be wild. It would be full control over the vice president. The president has full control over the vice president at that point, including what he does in Congress. Congress pass law on vice president role in certifying election. And that's some amazing foresight, because didn't Congress pass a law shortly after that whole debacle? The new provisions make clear that the vice president's responsibilities in the process are merely ceremonial, and that the vice president has no say in determining who actually won the election. The new legislation also raises the threshold required for members of Congress to object to certifying the electors. This is amazing, like 2020 vision here, okay? It's amazing that they passed this law shortly after that whole debacle. And it's amazing that they did, because if it turns out to be the case that the vice president is under complete control, or is in complete control from the president, so the president can order him to do whatever, basically, and it can't be questioned, then he literally could have he would have literally hold the whole election and sent that issue into chaos. So this is amazing that they passed that law right after that. That's crazy. Or at some point afterwards, right? I don't think it was like immediately after, but at some point, you know, it made its rounds through legislative process. So amazing. Simply amazing. The question then becomes whether the presumption of immunity is rebutted under circumstances. It is the government's burden to rebut the presumption of immunity. The court therefore remands to the district court to assess in the first instance whether a prosecution involving Trump's alleged attempts to influence the vice president's oversight of the certification proceeding will pose any dangers of intrusion on the authority and functions of the executive branch. Yeah, this is where like they're basically. I would be really curious to see what. Can I change this back to yellow? I'd be really curious to see like what the hell the district court even does with this. The court therefore remands to assess in the first instance whether a prosecution involving Trump's alleged attempt, because the thing is they're going to let the district court make the determination, and then they're just going to question it eventually anyway. So then it's just going to make its way back to the Supreme Court to be like yes or no. So, which I don't know. It's just honestly, this whole thing is honestly a waste of time, but it is still technically part of the proper process. But they could have just foresaw it and just made the decision themselves to save time. But that's obviously not what they want to do. This is crazy. Didn't Israel have an issue? Didn't Israel have an issue with like their Supreme Court? Israel issue with Supreme Court. Wasn't it like essentially the same thing? Issue with Supreme Court. On Monday, Israel passed a bill that strips Israel's Supreme Court of the power to declare government decisions unreasonable. Yeah, passed with a 64-0 vote. See, at least the Israelis like had the foresight to see that the Supreme Court saying that what the government can and can't do. I guess is a good thing, but then again, I guess this could obviously be really bad in a lot of different ways if applied to our Constitution's structure. So, moving on. I need to write this down or make note of this, right? So, lower courts, right? So lower courts need to make the determinations first. And obviously, this one I don't even need to put in my notes because this is obvious. And obviously, the Supreme Court will have the final say. And I don't know why I keep adding that extra M. Jesus, man. I hate my life. The indictment's remaining allegations involve Trump's interactions with persons outside the executive branch, state officials. Oh, no. Please don't tell me. I'm trying to think. Without looking, off the top of my head, what does the president do with other state officials? I can't think of anything necessarily. I know Congress empowers the president to sign off on things like FEMA. I mean, there's natural disasters. I think there's a requirement for the state to declare an emergency. Then the president can then send federal resources to the state. So I guess inherently there would be a connection, but I can't think of anything like what would the president naturally communicate with a state official for? I guess for maybe law enforcement activities, right? It probably would be law enforcement activities that he would argue. And then the thing is, he was talking to the state officials regarding like investigating the votes. If he made any mention of investigating anything regarding the election stuff, then everything that he was saying from that point forward, even if it had nothing to do with investigating ish, it was just a matter of just saying that, hey, we just get these extra votes and then we'll take care of the rest. Because it started off with investigating fraud, which I know that's exactly what he was doing at first, saying there's a lot of fraud, blah, blah, blah. I need to investigate. Since he is a law enforcement official, I guess technically, right? they're probably going to say that's immune. This would be what'll kill the Georgia case. I'm pretty sure this is what's about to kill the Georgia case. Let's see. Let's see. State officials. Bro, stop it. Okay, cool. State officials, private parties, and the general public. Oh, they lumped this all into one? Oh, that's wild. In particular, the indictment alleges that Trump and his co-conspirators attempted to convince certain state officials that election fraud had tainted the popular vote count in their states, and thus electoral votes for Trump's opponent needed to be changed to electoral votes for Trump. After Trump failed to convince those officials to alter their state processes, he and his co-conspirators allegedly developed and effectuated a plan to submit fraudulent slates of presidential electors to obstruct the certification proceeding. On Trump's view, the alleged conduct qualifies as official because it was undertaken to ensure the integrity and proper administration of the federal election. This right here. Does the president have an actual role over federal elections? At the top of my head, I don't think so. I do not think he actually has any role to play in federal elections, right? Like, as far as like as an arbiter or like a person in control of said election, he participates in it, obviously. If he is running for election or re-election, or running for re-election, obviously he's president, so he already won. But I don't think he has any lever or any type of anything to do with the actual process of the federal election. So this is a really important question here. Does the president go back to bullet points, right? Bullet lists, right? Does the president have an actual role over federal elections, right? Could be the killer for Georgia prosecution. This is what that is, right? Could be the killer for Georgia prosecution. As the government sees it, however, Trump can point to no plausible source of authority enabling the president to take such actions. Determining whose characterization may be correct and with respect to which conduct, don't tell me they're about to punt this off, requires a fact-specific analysis of the indictment's extensive and interrelated allegations. The court accordingly remands. They kick the shit down the road. What did I tell you? The court remands to the district court to determine in the first instance whether Trump's conduct in this area qualifies as official or unofficial. But this should be a no-brainer then. But I really do think this should be a no-brainer. I do not think he has any form of like lever whatsoever over the federal election. So okay, so maybe the Georgia case could be safe. Because even if, right, because then this would be closer about the vice president thing, right? Because even though you can say that he has some type of authority to communicate with state officials, being president of the United States, what's that word? I need to highlight it. I need to highlight it in this here. Excuse me. Here we go. Can I increase the font size of this? I don't think so. I actually don't think I can. Well, let me just bold and underline this. Just bold and underline this, right? And then, hell, what I'm even going to do, because this is going to be such an important statement, because this is going to be like the meat and potatoes for a lot of this court stuff, all right? A lot of this court stuff here. Let me copy that. Do this here. Yeah, I guess we can leave it like that, sure. Can I just, in that case then, can I just, hold on, go like that, go like this, enter. Why is it not together? Am I tripping? Why? We'll clean it up later. Okay, we'll clean it up later. I don't want to think about it right now. My brain hurts. Always something to figure out, man. So long as they are not manifestly palpably beyond his authority, right? Because this, so this would be easy, right? I think the district court is going to determine that this is beyond his authority for anything to deal with the federal election. So therefore, like the conduct is, can it be seen as this? And I think the Supreme Court would say that that is indeed the case. And this is actually going to be, because this would be tied to the Georgia state. And so even if he wins the presidency, this isn't something that he can dismiss. But of course, the Republican governor, the Republican state, because Georgia is Republican, they're just going to then dismiss it anyway. So that really doesn't matter. But if he doesn't win, though, I think the Georgia state may actually potentially do the right thing and then give him the business legally. Yeah, there's no telling how that'll turn out, or at least there's a good way of knowing like exactly how that'll turn out. I just don't know like what the actual end result will even be in the end. The district court is going to say that he didn't have the authority. Supreme Court is probably going to say this is indeed the case. There's nothing in the Constitution that says he has authority over it, and then that's it. But I don't think it's even going to change anything because Georgia, if he wins the presidency, is just going to then just dismiss it. Okay, so let's see. But like I thought, I knew they were going to kick the shit down the road and not just make the determination themselves. The indictment also contains various allegations regarding Trump's conduct in connection with the events of January 6th itself. If I look back at the January 6th stuff, all that's going to be thrown out for sure, right? Because all he did, he gave a speech. Congress already did their thing with the impeachment process. There's nothing you can, even if this came out before, then it wouldn't stop Congress from being able to impeach him. Right? Because that's the core legislative branch duty, right? And they're not a criminal thing. So I'm pretty sure they're probably going to say that all that's thrown out. Everything about the January 6th thing. So him giving that speech and then telling them to go down there and then they raise hell or fight like hell, whatever it is, all that's going to get thrown out. It's all going to get thrown out. I'm pretty sure that's what's going to happen. So the alleged conduct largely consists of Trump's communications in the form of tweets and in a public address. The president possesses extraordinary power to speak to his fellow citizens and on their behalf. Trump v. Hawaii. So most of a president's public communications are likely to fall comfortably within the outer perimeter of his official responsibilities. There may, however, be contexts in which the president speaks in an unofficial capacity, perhaps as a candidate for office or party leader. To the extent that may be the case, objective analysis of content, form, and context will necessarily inform the inquiry. Snyder v. Phelps. Whether the communications alleged in the indictment involve official conduct may depend on the content and context for each. This necessarily fact-bound analysis is best performed initially by the district court. The court therefore remands to the district court to determine in the first instance whether this alleged conduct is official or unofficial, right? So like I said, this is all going to deal with his speech, right? If I read that correctly. Yeah, content, form, and context. Yeah, none of that's going to matter. Like, it's just, I mean, he has an official duty to speak to the public. I can't see how the district court, I think, would say this is an official act. I can't see it being ruled any other way. I'm not, again, disclaimer, right? Not a lawyer, so I don't know. But I can't see the court really saying this would be determined any other way. The presidents cannot be indicted based on conduct for which they are immune from prosecution. Okay. Well. Oh my God. Drop it. I know. We're gonna add that to our shopping list in the distant future. Because there's nothing wrong with my keyboard. Therefore, I will not be replacing it anytime soon. But at some point, I've had it for a couple of years, and it clearly is like has not been working for me. So we'll just look at something else. Presidents cannot be indicted based on conduct for which they are immune from prosecution. What this says to me is that this means that he can't even begin to be charged. this tells me, okay, the president cannot even begin the process of being charged for something if it is related to something determined to be an official act, right? So an example of this would be like this, the civil shielding, right? How the president can't be sued, right, for anything. So how that's already determined, that's inherent. So once this stuff gets ironed out on what's official and what's unofficial, if he does anything that is seen, right, whoever like feels it to be the case, if it is seen as a crime, but it has already been determined that what he did was an official act, then no court system can even begin to attempt to try to take it up. It's completely immune. So we're still on page. Oh, we're on page 7 now. Where did I get the page 6? Is this all page 6 stuff? Hold on. The indictment. What empowers the president? Hold on. See, wasn't even paying attention to what I was doing. For alleged conduct, does not strip. Does not vest. Okay, so it's right here. This one's page 6. Okay, and then just come back and clean it up later, right? And then here we go. Now we're in page 7. Page 7, and then let's bullet. Paste this. Okay. President cannot be indicted based on conduct, right? So the court system can't even entertain it. Period. How lovely. On remand, the district court must carefully analyze the indictment's remaining allegations to determine whether they too involve conduct for which a president must be immune from prosecution, and the parties in the district court must ensure that sufficient allegations support the indictment's charges. Without such conduct, testimony or private records of the president or his advisors probing such conduct may not be admitted as evidence at trial. Here we go. Boom. Testimony or private records of the president or his advisors probing such conduct may not be admitted as evidence at trial. There we go. These red ones are coming. Right? Nothing belonging to the president, verbally or in writing, that is not public can be used as evidence, right? Crazy. Absolutely crazy. Nothing belongs to the president, verbally or in writing, that is not public can be used as evidence, right? So Trump asserts a far broader immunity than the limited one the court recognizes, contending that the indictment must be dismissed because the impeachment judgment clause requires that impeachment and Senate conviction precedes a president's criminal prosecution, but the text of the clause does not address whether or and on what conduct a president may be prosecuted if he was never impeached and convicted, right? So this is just basically saying that yeah, as far as like the whole impeachment process doesn't actually, I did not mean to do that. The whole impeachment process does not, I'm not going to note that down, does not actually specify anything about criminal conduct or criminal, the whole criminal process for a president, whether he was impeached or not. So historical evidence likewise lends little support to Trump's position. The Federalist Papers on which Trump relies concerns the checks available against the sitting president. They did not endorse or even consider whether the impeachment judgment clause immunizes a former president from prosecution, transforming the political process of impeachment into a necessary step in the enforcement of criminal law. Finds little support in the text of the Constitution or the structure of the nation's government. The government takes a similar broad view, contending that the president enjoys no immunity from criminal prosecution for any action on its view as applied challenges in the course of the trial. Suffice to protect Article 2 interests and review of a district court's decision on such challenges should be deferred until they nervous. I don't know why. Should be, hold on, I lost it. The president enjoys no immunity on its view as applied challenges in the course of the trial suffice to protect Article 2 interests, and review of the district court's decision on such challenges should be deferred until after trial. But questions about whether the president may be held liable for particular actions consistent with the separation of powers must be addressed at the outset of a proceeding. Even if the president were ultimately not found liable for certain official actions, the possibility of an extended proceeding alone may render him unduly cautious. Oh my God, bro. Are they really about to give him this too? I need to read this whole section one more time. On its view, the government takes no similar broad view, contending that the president enjoys no immunity from criminal prosecution for any action. It's crazy that they were speaking and said that there's nothing in the Constitution that will promote that he's immune or that he requires impeachment before he can be criminally prosecuted. There's no like historical writing or historical documents. The government isn't even structured in that manner to sit there and say that the president or that anybody really could be immune in the manner in which he's speaking. But it sounds like to me they're about to give him another immunity shield for it. I need to read this. The government takes a similar broad view, contending that the president enjoys no immunity from criminal prosecution for any action. On its view, as applied challenges in the course of the trial suffice to protect Article 2 interests, right? So, if I'm not mistaken, yeah. So when we get to reading the actual Constitution, because we got to actually look at these articles and see like who gets their originating power from what. I think Article 2 is just exclusively the president, the executive branch. On its view, as applied, challenges in the course of the trial suffice to protect Article 2 interests. See, they're setting this up to say, right, because it would be in favor of the president's official duties. This is what they're setting it up for. And review of a district court's decision on such challenges should be deferred until after trial. I don't necessarily understand what this section means, but questions about whether the president may be held liable for particular actions consistent with the separation of powers must be addressed at the outset of a proceeding. Right? We're going to even Google the words that we think we understand, right? Because you never know. Outset definition, right? The start of or beginning of something, right? So the outset, right? Because like these are things that need to be hashed out before you even before you even start getting deep into something, right? Because that's what I figured out outset was meaning, right? So it sounds like they're gonna make this decision for him. But they won't make the decision on a lot of other things. They'll send that back to the district court, but they're gonna make this decision for him though. Even if the president were ultimately not found liable for certain official actions, the possibility of an extended proceeding alone may render him unduly cautious in the discharge of his official duties. The Constitution does not tolerate such impediments to the effective functioning of the government. Oh man. This is crazy. This is so crazy. This is crazy. Well, no, I can leave it red, right? Right? Yeah, I should actually leave it red because this is basically saying that even if let me make sure I need to make sure it just sounds right before I even try to type it out, right? So even if the government takes a similar broad view, transforming the political process of impeachment into a necessary step. So even if there could be, because it sounds like they're also saying too that even if this was the case for like impeachment, the fact that the president can be impeached about it shouldn't stop the president from being able to take said action, even if it was the case that after a full impeachment, right, that means the impeachment and then the conviction by the Senate could even lead to criminal prosecution. So they're taking that out of the equation. So even if it was the case that the president could go to trial for conduct after being fully impeached, this is something that would encroach into him being able to perform his official duties. Therefore, it is not allowed. Beautiful. Encroached. Encroached. Is it encroached? I thought it was enroached. No? It might be actually encroached. And I'm just encroach, right? Encroached. Would encroach into. Oh my God! Stop it. Would encroach into him being able to perform his official duties. Yes. So we know this is crazy. I'm technically in a page 8. So, but it's fine. It starts off at page 7, so we'll just leave it at that. Even if it's the case that the president could go to trial for conduct after being fully impeached, that is something that would encroach into him, something that would encroach into him being able to perform his official duties, therefore is not allowed. This case poses a question of lasting significance. When may a former president be prosecuted for official acts taken during his presidency? Okay, so here we go, right? So, well, no, because no, they're just going to say that he just can't, right? Any action that he took as president is immune. It would have been nice if this leads into asking, like, if he can be prosecuted. Golly, if he can be prosecuted for things that are a knockoff from an official act taken while he was president. That's what I would love to hear. In answering that question, unlike the political branches and the public at large, the court cannot afford to fixate exclusively or even primarily on present exigencies. I want to make sure I'm pronouncing these words correctly. Exigencies. Exigencies. Is it exigencies? Exigencies. Exigencies.
Exigency.
Exigency? Ooh. Exigencies? Exigencies. That's
Exigency.
exigencies. That's a terrible word. Well, present exigencies, enduring separation of powers principles guide our decision in this case. The president enjoys no immunity for his unofficial acts, and not everything the president does is official. The president is not above the law, but under our system of separated powers, the president may not be prosecuted for exercising his core constitutional powers, and he is entitled to at least presumptive immunity for prosecution for his official acts, right? So with this, okay. Needs to be made clear what are core constitutional, well, no, they say constitutional acts. Or core constitutional acts, and can statutory powers be delineated? I hope that's right. Delineated from them. Right? When I say subtiered, I think I say subtiered. Subtiered. All right. At least presumptive. So not being prosecuted. So what I'm getting at is that because they say the president may not be prosecuted. So by saying not be prosecuted, that is absolute immunity. That's what the absolute immunity is for. Not be prosecuted. Presumptive immunity is the question can be asked and hashed out, and then we will look and see. That is what that means. So I think that I want to say, right? I mean, I've read it earlier. It's just I'm not 100% on it. I want to say the actual constitutional stuff is absolute. And maybe the sub-tiered stuff, what I call sub-tiered stuff, which would be the stuff that's passed on from the Constitution, right? Because everything relies on the Constitution authorizing it, would be presumptive, is like kind of how I would read that. Hold on. Page 8 / bullet. So this is my page 8, right? Needs to be made clear what are core constitutional acts and can statutory powers be delineated from them, right? So the president, because right, the president doing military stuff is constitutionally directed, right? It's not necessarily congressionally directive. Of course, there's like certain authorizations for stuff, but but the stuff that is constitutionally empowering, like I think like what was it, like the Gulf War or something like that or whatever. I think it was like after 9/11. I can't think of it right now, but like he's able to take actions and stuff because of an authorization that was granted like 20, 30, 40 years ago, whatever, from Congress. Maybe actions taken under that could be presumptive, but then his actions under the military itself is absolute. So how would you delineate between those two? So very interesting. Like, I would wonder. So then, like, because then the question, I'm just curious if there is such delineation. How do you satisfy it when the statutory blends directly into the constitutional authority, i.e. Congress gives the president the power to use the military for a much longer length of time than what is initially authorized by the Constitution for a certain geographical area, and the president starts with this but then goes into another area. All right, I need to clear up that example some. Hold on. Bro, stop it. Stop it. Okay, Constitution gives the president, of course, man, those, oh God. Okay. All right, if there is such delineation, how do you satisfy it when the statutory blends directly into the constitutional authority, i.e. Congress? Because right, I think there's a time limit where like the president could take initial solo action with regards to the military, but I think after 30 days or something like that, he needs like further authorization from Congress. So like if Congress just initially authorizes him to do something, but they put restrictions on his use of the military on it, but then he uses the military to do it anyway, could it even go through the court system about it, right? Because he has the authority to do essentially like whatever actions he want with Congress. Congress authorized him to do something. Let's say they just authorized him to do something for 90 days, but they restricted it to be in a specific area. He has still full control of the military. So while he's in that area, he authorizes them to take an action outside of that area. Can Congress do anything about it? My initial answer would be yes, because I keep forgetting that Congress is not a criminal body. It's not a criminal investigating body, right? So they could just subpoena him, but I don't think they could. He basically, right, because what Congress passes a law, right, that say, hey, the president can do this. He would have violated the law by taking an action, but he couldn't possibly be prosecuted for it. He could potentially be impeached, but holding him criminally liable for it would be off the table, right? So I want to have like a really good example here. So like if I go to, here we go, right? If, for example, right, he has authorization to do whatever he like, let's say like one of those like prior things authorizes the president to do stuff in Iraq. And while he's in Iraq, he actually does something in Iran, and then next world war breaks off, right? He would not be criminally liable. I wonder if he would not be criminally liable. So he gets to be scot-free for that, for essentially causing like the next world war by taking his authorization for Iraq and then doing some ish in Iran, because he has the power to do that with the military in Iran. So the military does it. And then Congress, and then Congress impeaches him for it, but he can't be held criminally liable for it. So many people will die, right? It's the next world war, right? So lots of conflicts and stuff happen, and he literally gets to be scot-free. I wonder, and then I guess the international court. Next question would be the international court, right? Let me see something here. If the international court said the president violated a international, what do I call it, law or international convention, does the U.S. government even have the authority to send him off, even if the government was willing, right? So that example I just gave, right? Authorized action in Iraq, uses that to do something in Iran that causes a whole bunch of problems, maybe a violation of Geneva Conventions, whatever it is, right? Or, whatever international body stuff, right? International body, just similar to like how like they put a warrant for arrest for the Israeli prime minister and the Hamas leader, right? If the president violated a international like convention or something, right? And then they order his arrest. If let's say after the election cycle, you get a new president that would be more than happy to send the previous president out there to be prosecuted. So, and then, of course, he has full control of the government right now, law enforcement. Does he even have authority to do so? I don't think so, right? Because it would be seen, because wouldn't it be seen as circumventing? Wouldn't it be seen as circumventing the immunity that the president had? Because I think that would be the case, right? It would be sending him to be prosecuted by like an international body would be circumventing the immunity that the president of the United States enjoys. Therefore, that action would have to be illegal. Therefore, they couldn't even send him before the international court to be prosecuted. So we literally do have a president. We literally have a presidency that could commit a crime overseas, and the international world could do nothing about it unless they were going to come into the U.S. and get them themselves. That is crazy. That is kind of crazy. Huh. I guess technically you could say that's already the case, right? Because obviously the Israeli prime minister isn't about to go nowhere. And ain't nobody about to come get him or go get him. And I think the answer is the same thing for the Russian president. So I guess maybe that puts it in. But like this would be in front of like actual this would be crazy. I can't say actual war crimes because obviously like the Russia stuff, actual war crimes, right? The Israeli stuff is a little bit not as clear. This is crazy. This is crazy. So it's like even if so like the US is even hamstrung and even trying to adhere to that, I think. That's what that sounds like to me. I think that I think this literally keeps the government from actually also adhering itself to the international norms as well. Interesting. That immunity applies equally to all occupants of the Oval Office. Huh. All occupants of the Oval Office. I wonder what, when they say all occupants, what do they mean? You're talking about just the president or everybody that be in the Oval Office? So his secretary and all the other stuff. Okay. Vacated and remanded. I don't know. Roberts, CJ delivered the opinion of the court in which Thomas Alito, Gorsuch, and Kavanaugh joined in full, in which Barrett joined except as to Part 3C. Thomas J. filed a concurring opinion. Barrett J. filed an opinion occurring in part. Also, Barrett said part of this is cool, part of this isn't. Sotomayor filed a dissenting opinion in which Kagan and Jackson joined. Jackson J. filed a dissenting opinion. Okay. I never understood how exactly these work, right? Because I thought these were only just like still like separate statements, but like they did their opinion together and then he just did his separate. Is that how I read that? Mm-mm. Okay, opinion of the court. Chief Justice Roberts delivered the opinion of the court. This case concerns the federal indictment of a former president of the United States. So this is what I'm gonna do, right? We're gonna have to obviously break this up into parts here. I want to say just already off the bat, before we even get into delivering the court stuff, like the information is pretty clear that he's immune from official acts, and what those official acts are not determined yet. It's going to have to be hashed out in the lower courts. So we don't even need to really go any further, because this is just going to turn about the methodology and speak other stuff, and all this is going to be boring. We're going to actually read the dissenting opinion. We'll read the dissenting opinion, and maybe later on we might come back and then like read the rest of this, but I'm not about to go through all 119 pages, right? Because one thing I always hated is just repetitiveness, right? Because it's just all going to be just the same stuff. So it's all going to be the same stuff. And I don't really care for that. I just want to know like what's officially being granted here. And officially his core acts are immune. That's it, right? They're absolute immune. And then there's other stuff that could be presumptively immune. And what is presumptively immune is the stuff that's not quite hashed out yet. We have to wait for the court system to hash that out. So, and we got some information already about like what could be presumptively immune, what might not be. Well, not really what might not be, but what would be presumptively immune. So yeah, so there's actually really no reason for me to really even read the rest of this. So what we're going to look for now, we're going to look for the dissenting opinion. So what did they say? Who dissented? Let's see. So what I'm going to do is I'm definitely read Barrett's decision in part, right? So he's saying some things are good and some things are not. That's actually going to be interesting. Let's find this. Barrett, where's your opinion? Barrett, here we go. Concurring in part. What is this? This is page 61. All right, we're going to read this. Under no course, like the dissenting thing. The dissenting thing, we might read later on, but all that's just going to be they just disagree with it, and they're going to say, like, they're probably just going to be like, yeah, this is crazy. He becomes, like, basically king. He can't be tried for anything, blah, blah, blah. Right? Which is important. Don't get me wrong. I ain't saying it's not important and it's not crazy, but I just want to read stuff that gives me some new information here. So let's see. Justice Barrett concurring in part. For reasons I explained below, I do not join Part 3C of the court's opinion. The remainder of the opinion is consistent with my view that the Constitution prohibits Congress from criminalizing a president's exercise of core Article 2 powers and closely related conduct. This makes sense, right? Okay. That said, I would have framed the underlying legal issues differently. The court describes the president's constitutional protection for certain prosecutions as an immunity. As I see it, that term is shorthand for two propositions. The president can challenge the constitutionality of a criminal statute as applied to official acts alleged in an indictment, and he can obtain interlocutory. Is that how you even say that? Interlocutory. Oh, I like that, because this obviously has a dash here, but they didn't have it when I copied it. That's cool.
Interlocutory.
Interlocutory, right? Interlocutory. Given provisionally during the course of a legal action. Provisionally. Okay. And the provisionally was subject to further confirmation. Yeah. Right. Okay. I'm just making sure I actually do understand these words. Interlocutory. I forgot it already. Interlocutory. Okay. Interlocutory review of the trial's court ruling. And he can obtain interlocutory review of the trial's court ruling. Hold on, but if this is given to him, provisionally given, but this would mean that he would be provisionally immune, right? Of the trial's. I might be reading that wrong. There appears to be substantial agreement on the first point. Like the court, the dissenting justices and the special counsel all accept that some prosecutions of a president's official conduct may be unconstitutional. Brief for United States, blah blah. As for the interlocutory review, precedent recognizes that resolving certain legal issues before trial is necessary to safeguard important constitutional interests here. I think what he might be saying here is that, like, so that thing I was saying earlier about like how like the question can't be asked, like he just can't be prosecuted, period, for court acts. I think he's saying that it should have still been allowed to been questioned in court, and then maybe like see like if it can be modified or maybe exempted in certain instances. I think maybe might be what he's trying to say here. Important constitutional interests here. Executive branch independence on matters that Article 2 assigns to the president's discretion. Properly conceived, the president's constitutional protection from prosecution is narrow. The court leaves open the possibility that the Constitution forbids prosecuting the president for any official conduct, instructing the lower court to address that question in the first instance. CMT at 14. I would have answered it now. Exactly. This is what the big problem is. Why not just talk about it now? We already know that whatever the lower court says is going to be challenged in either instance. Period. It's going to be challenged in either instance. Why not save the time and just make the answer now? Though I agree that a president cannot be held criminally liable for conduct with his conclusive and preclusive authority in closely related acts, the Constitution does not vest every exercise of executive power in the president's role, in the president's sole discretion. Yeah. And then there's more citations. Congress has concurrent authority over many government functions, and it may sometimes use that authority to regulate the president's official conduct, including by a criminal statute. Article 2 poses no barrier to prosecution in such cases. I'm going to read this one more time. I need to make sure I understand this, right? Congress has concurrent authority over many government functions, and it may sometimes use that authority to regulate the president's official conduct, including by criminal statute. Article 2 poses no barrier for prosecution in such cases. This is interesting, right? Because what he's saying is, because like earlier in this whole decision thing, right, they were saying that like certain things that would be shared between the president and Congress cannot be granted immunity. So therefore because of the fact that there's a lot of entanglement between Congress and the executive branch, for Congress passing laws and then the president having to enforce them and stuff, that could be the potential nexus or gateway into, you know, the whole criminal prosecution of the president potentially, right? Or that he couldn't possibly be immune. He couldn't possibly be immune because of that nexus. Let me see, page, what is this, page 62? Ooh, wow, I actually held it. That's crazy. I was about to sneeze. I wasn't trying to hold it, but I want to make sure, cover. Don't want sneeze fluids all over. Hold on. Where is, okay, I need to change the color to this on yellow here. And yeah, so, can we just, oh yeah, we can just change. Okay, so whole time I was sitting and deleting it and putting it back. I don't have to do that no more. So what is it, right? So Congress and the executive branch have a lot of interwoven things. Let me just make sure I read it right. Congress has concurrent authority over many government functions, and it may sometimes use that authority to regulate the president's official conduct, including by criminal statute. Article 2 poses no barrier to prosecution in such cases. Congress and the executive branch have a lot of interwoven things, lots of interwoven authority. So it could be the case that Congress could be able to regulate presidential authority, presidential conduct, right? Presidential conduct, right? So it could be the case that Congress could be able to regulate presidential conduct to include the use of criminal statute. Now that I reread this, I actually don't think this is the case, right? Because they can't make a criminal statute. Well, let me think about this. Maybe it actually could, right? Because you wouldn't make a criminal statute over something that the president has authority to do. You would make a criminal statute if you give the president authority to do something new that has to be used in a certain way. So maybe it could be the case if they gave the president the power to... I'm trying to think here. I'm trying to think of a simple example. I was about to go with like martial law, like setting curfews, and it's saying that if you set a curfew outside of these hours, it's it's a criminal violation, and therefore you could be prosecuted. Right. So let me think about this. I guess that example kind of works, but it'd be a bit convoluted. I guess if the president had the power to set the required balance everybody needs to have in their bank accounts, and says that by law the president can determine whether everybody must have $100 or $200. $100 up to $200 in their bank account at all times. He gets to set the value, but it has to be within this range. And then they specifically say that any range set outside of this value will be considered like a criminal act, and therefore is subject to being criminally prosecuted. I think they could do that. I think they could actually set that up or structure it that way, because it's not encroaching. It's something new. It's a new power granted by Congress, right? It's not inherent by Article 2. Not inherent by Article 2. So if he uses that power and then does violate it, your mic staticking a bit. Oh no. Let me see. 4 hours. Maybe it could be because my AC is on now. Let me see something. Hold on. Oh wow. My computer is hot. Hold on. You know something? I didn't turn on. I got a new like fan pad. In fact, I just finished watching this video. Oh, cool. We'll look at it too. Hold on. So my computer's definitely really hot. So yeah, I forgot to turn on my cooler pad. So I have a cooler pad that should hopefully help cool down. See, when I have money, I'm gonna just get another desktop and have the desktop mic test. Mic test 1 2 1 2. I don't know if does it sound better? I don't know. I'm trying to bring the temperature down on it. I'm hoping that the air stuff I'm pushing out should be still staticky. Okay. Hold on. Can I lower this down a little bit? Okay. I turned down the mic a little bit because the staticky could be too that it's like reaching like some threshold. So I'm hoping that's not the case. Is it still staticky? Actually, it should be because that actually still blew up. It crossed the red. Let me turn it down just a wee bit more. Okay. Now is it breaching the red? It's not breaching the red no more. Even with me talking like that. Does that help? Yes, it's good. I'm gonna say that that's a yes, that we are good now and it's not being staticky no more. And I turned around for a second and it went back into the red, so it's still staticky. So yes that it's still staticky, or yes that it's good. No, it's not good. Okay. Turn you down more. Turn you down more. Okay. Now, is it still staticky? If it's still staticky at this point, then I know that it could be because my computer is having a hard time actually processing. That's the next thing. Still is. Okay. So still staticky. All right. Give me a moment. Okay. One moment. Breath. What do I want to do? I wonder if... Hold on. Hold on. Because it'll probably take a while too for the cooler pad to take enough heat away from it. I'm waiting for some mail too, because this cooler pad has 2 USB ports that I assume, like, if you had them both powered, it would give the fan a lot of power to blow air. But they gave me only 1 USB cord. That is all. It only needs 1 to work. Okay, I guess. But I'm assuming that it can use both to, like, for extra power. So why not just give me 2 USB cords? And then of course it's a female USB cord, right? So now I had to get a specific. So I had to order online because I don't have a USB male to male end, because it's you need 2 male ends in order to plug it up. It wasn't like, like micro USB or USB-C to regular USB. So that was like a huge pain. Okay, so this is what I'm gonna do. I'm actually going to flip this over now. Let's see if this changes anything. So hold on, let's see. 78 degrees Celsius. What the hell is that? 78 degrees Celsius. That sounds hot as hell. Can't I just change this to Fahrenheit? Why do they have it in Celsius? All right, this is America. Okay, we do everything different. Let me see something. Hold on. Default. Do we have an option to change this? Capture hypervisor pages. Capture user pages. No? No? I would go out of my way to find an unsafe way to mod Windows to get that garbage off my computer. And writing something in Celsius. Alright, that tells me nothing. When my life has revolved around Fahrenheit. Real-time update. Performance. Specify which page is visible when launching the blah, blah, blah. Yeah, so there is no Wi-Fi, so I do have to actually just look it up. Celsius sounds crazy. 71 degrees Celsius. 71 Celsius to Fahrenheit. 159 degrees. Oh, I'm sorry. It's not 71. It's 78 degrees Celsius to Fahrenheit. Huh? Oh. It's like, what the hell? 172. Okay, so this is why it's like starting to spaz out. It has actually managed to get really hot. All right, just give me a second. Let me figure something out. Um, I know what I can do. What application is it? Hold on. I have an application. I have an application that does a really good job in giving me different data points for temperature on my computer. What the hell are those applications? Is it Nextcam? Let me see. Hold on. I gotta open up. Come on, let me move it over so you can actually see here. Hold on. Of course, it has to update. Lovely. This Nextcam. Jesus Christ, man. Come on. Bug fixes. Rollback PC monitoring update to resolve the following issues: incorrect CPU readings resulting in visual display of incorrect higher CPU temperatures. Sorry about that. Blah blah blah. Blah blah blah. Come over here. Can I go back now? Does this tell me? Yes, so this does give me the temperature for the CPU and the GPU. So this is what I need to install on the Utter computer. Okay, so because remember, this is my desktop computer we're looking at here, and then my other computer is the one that's doing the thingamabob. So I need to be able to do the thingamabob. And okay, so let me refresh. So hold on, I'm hoping this. No, it's still getting hotter. It's at 79 degrees, bro. What's heating it up? Something's heating it up. I don't know what's heating it up, but we gotta figure it out. I need to get that other damn USB port, man. You know what I think I can do too? I think next time I'd have to restart the stream in order to do it, so we'll do that next time. But I think I could I like potentially like lower the load if I were to if I was to like to reduce like one of the codecs thing here. Hold on. So if I bring this over here, so right now on my Microsoft Surface Studio laptop thingamabob, right? This is what I'm streaming here. I am streaming. Let's see. It is under slower and high quality. 2 passes, quarter resolution. Because this was especially good for what's the word I'm looking for? Fast action stuff. Whenever I was like doing like certain games and whatnot. Because I hated when the fast action movement was a bit blurry, generally blurry. So this is what I was able to get in order to get it to not be as blurry. It could actually look pretty good. But we might want to we might drop the slower preset. I think the slower preset. Oh, can I actually change it now? What do I have for? I'm gonna do it based off of what I had for my DaVinci Resolve application. Oh, we're gonna look. I just need to look and see like how I encode my videos, because I think I dropped this. I don't think I do slower. I think I do. I think I dropped it down to medium for when I actually do my video encoding. So we'll see. I'm waiting for it to load up. It's loading. Here we go. Yeah, I could just open an untitled project. It's fine. Okay. Let me go here. Let me go to my, whenever I'm doing 4K videos, what do I have it set? I have it set to slow. Okay. High quality. Yeah. I don't have to worry about the passes, because it's a static contact, right? I think like because when I was testing it, there was no difference between doing 2 pass disabled and 2 pass on all the other ones. But the when we're talking streaming, however, there's a really noticeable difference with fast action stuff. We're currently on slower, so let's just say slow. I hope this doesn't crash anything. Where's you? 80 degrees. Bro, why is it getting hotter? I can't just have the AC just going at it. Hold on, I just want to move this over here. Can I go like this? Okay, that's fine. Okay, let's go slow. Let me go back here real quick. 81 degrees is still rising. This is a huge problem. Let me see. 63 roughly. The encoding, right? It's encoding that's going to potentially be affected. The 3D and encoding maybe. So let's see. So if I drop that down, I see no change. I literally see no change. I'm actually really shocked that it's even letting me do this while I'm streaming. So if I said slow, if I brought it down to its slowest, I'm sorry, not slowest, but its fastest. I see no change. I want to change all those other things though. Not without adequately testing. 3D dip for a second. Okay. I need to figure out why is my laptop acting like it's a furnace. 80 what? 81 degrees. Isn't this... We're breaching into like getting closer and closer to 180. 180 would be a bit problematic. I don't know what to do to make it calm the hell down. The graphics card can't possibly be. It's not like it's changing any. And the worst part is, it's not even changing any workloads. And that's because I don't know if like the stream has to be restarted in order to test that out or not. Okay. Well, let me think about this. Could I make the CPU work on some other stuff? All I have left here it's just kind of hold. I think it's just literally just kind of hold. Is it still staticking? If it's still staticking, you might be hold on this one. I'd have to redesign my setup here to figure out how I can prevent this from overheating the way that it is. Let me see. Testing, test. Okay, no. So that's the other microphone. Don't want that. Now to my actual mic. There we go. Right. So this should be back. I think it must have. It probably like for a split second like disconnected, and I just needed it to get back. Okay. Okay. I'm hoping, and hopefully maybe that could even maybe fix the static stuff. Is the static stuff at least not a problem anymore? All right. It would be really cool if it's not staticky anymore. And what the hell happened? How is it no more static? Not only is it no more static and perfect, right? But it dropped significantly in temperature. What happened? Wait, what happened? I literally changed nothing. I was playing with stuff, but I put it all back. What happened? Right? I'm not tripping, right? It was at 81 degrees. How did it go from 81 to 67? That's crazy. That's crazy. That is actually crazy. What the hell is it doing? Yeah, like that's. I literally changed nothing. Let me go back. Let me go back. Right? I changed nothing. Right? And then I did it all while streaming. Right? I put this to slow, but that was it. And like as far as like the actual workload, it didn't change nothing. I left that be, left that be, left that be. That's crazy. Or maybe it took a second for the slow thing to kick in, but like by that much, nah. All right, well, we figured it out at least. I think, maybe. And then when I get a chance, I need to install this application onto that computer so I can actually get a read of like the CPU. Because this is what my desktop computer is running right now, right? 70 degrees on the desktop for the CPU, 41 for the GPU, right? Because my desktop obviously isn't doing anything graphic intensive. So, oh man, here is so dry. I haven't put anything in it because I was planning on washing it tonight. It's already or super early this morning. And yeah, and then like putting all the stuff on it and then throwing all the things that you'd be seeing me putting on to get the hair right. Okay, I close this. And how many pages does this guy write? Okay, it's not that many, right? So what we're gonna do is we're gonna finish his opinion. I'm just curious of like what were the things he agreed on, what are the things he didn't agree on, and then yeah, then we're gonna actually grab that, and I don't want to lose it. I'm gonna grab that video you said you watched. Yeah, this one. He clicks it. Doesn't realize. Oh, Shapiro made a statement and Destiny reacted on it. That'll be good. Yeah, we're gonna. Yeah, that could be the first video we actually look at and watch for sure. I'd be really curious to see like what was Shapiro's take on it. And Shapiro's a lawyer. If I'm not mistaken, Shapiro is a lawyer, right? I think he is an actual lawyer. I don't know if he's if he ever practiced criminal law, but I think he's a lawyer. So I'd be really curious to see like how he kind of pushes or stretches like any of that stuff. So okay, yeah, let me enter here just so I can have it like kind of loaded up. I can't hear anything. I'm pretty sure you could probably hear it just fine, but for me, oh wait, do you actually even, let me see, hold on. Oh, Jesus Christ, nope. Because I don't even see any, huh. Oh, that's probably why it dropped. Now it's starting to make sense why the temperature dropped. I think it's somehow, oh, yeah, the Elgato thing is actually frozen. I'm talking just fine, but the Elgato thing is actually not okay. Okay. So, and that now it makes sense. Now I understand why it started dropping. It started doing a lot less work because it doesn't have to actually deal with the Elgato thing anymore. Perfect. Okay, so that's easy, right? Because all I gotta do is just deactivate it and reactivate it. That's all I have to do. So, deactivate. We give that a second. Reactivate. right? I reactivated it. No? No? Still not gonna show me. Right? Let me change it to like my Surface camera, right? Okay. And now we're going to now come back here to the Elgato. Huh. Yeah, we're gonna find out. We're gonna Google that and figure out like what kind of law he practiced for sure. Okay. Something's up with our thing. What happened? Let me see something. Whatever reason, it's not working at all, period. So what I need to do, I think I should be able to just disconnect it and reconnect it. I think I should be able to do that. We'll see. I'm scared because I'm doing this all while streaming. All right, I'm going to disconnect it. All right. We disconnected it. I'm going to reconnect it. I'm waiting for it to come on. Okay, it is back on. Let me go here to properties now. Okay, it's a black screen, so at least that's good. That means it could be starting to roll back up, right? Right? Come on. My monitor still isn't up yet. It's still trying to cut on. It's back down. Okay, why is my monitor not cutting back on? Harry. Everything is falling apart. Let me deactivate. Right. See, okay. Let me eject it. And I'm gonna plug it one more time. Okay. I'll make sure that the cords, right? My cords are not wiggled out somehow or some way. And then I'm going to now plug it back in. Okay. My computer's doing the flickering thing because it's starting to recognize that a new monitor is now being connected to it. Come on. I know we got it, right? HDMI 2. Why is it saying? Well, okay, yeah, there we go. Cool. All right, so my monitor's up now. Now let's reactivate. Reactivate it in OBS. Okay. Okay, yeah. Activate. Boom. There we go. All right. So now the only thing for me to check is audio. There we go. Yep, I heard it go through from Elgato. We'll play the video real quick to see. Make sure.
Does speak to the military. The military does control SEAL.
Okay. Yep. Bam. We're all good in the hood now. All good in the hood. What is this? Oh, it was election day, so I can close that too. Motive. Oh, so now the only thing I'm just curious now is just what's the temperature looking like back on the GPU. GPU is now the 72. So 69 to 72 going up to 73. That's just because it's just now doing a lot of video decoding work. So I think a bulk of my computer's work comes from the Elgato capture card, because the capture card, right, has a lot of rendering stuff that's being done through its GPU. So, and that's different from the streaming, right? Because I think the streaming is done on the encoding side. So it's not like a particular thing's being maxed out. Like everything's being spread equally around as far as the graphics cards like work components are concerned. I just don't like that it's just creeping up hot. But hopefully hopefully at 73 degrees or 75 degrees, right, we should be good. Because I think only when it got to like 77 or 78, where like we started getting those problems. So I'm hoping. And then now that I have the fan on, we should hopefully be good. So with that being said, let us. Okay, I can close this now. Elgato to be good. Okay, cool. All right, let's just finish up. I just want to finish up that particular section, and then we'll go from there. Where is my constitutional? No, I don't want that. Oh, Acrobat. Yeah, I'm tripping. Where are you, Acrobat? You're over here. Okay. Yeah, so let's just finish up like with this guy sitting here saying, and we'll go do it from here. Did I finish this? I did. Okay, so this is what, page 62. All right, Congress and the executive branch. Wait, why is this circle out? This should not be the case. There we go. I don't like the circle was see-through. Congress and the executive branch have a lot of interwoven authority, so it could be the case that Congress could be able to regulate presidential conduct to include the use of criminal statute. Okay, so let's see. I would thus assess the validity of criminal charges predicated on most official acts, i.e. those falling outside of the president's core executive power, in two steps. The first question is whether the relevant criminal statute reaches the president's official conduct. Not every broadly worded statute does. For example, 965 covers conspiracy to murder in a foreign country and does not expressly exclude the president's decision to, say, order a hostage rescue mission abroad. The underlying murder statute, however, covers only unlawful killings. The Office of Legal Counsel has interpreted that phrase to reflect a public authority exception for official acts involving the military and law enforcement. Because of my limited understanding, I'm actually having a hard time understanding what they could mean by this. So they're saying that there's a rule for unlawful killings that maybe could be applied but shouldn't be. The underlying murder statute, however, covers only unlawful killings. The Office of Legal Counsel has interpreted that phrase to reflect a public authority exception for official acts involving the military and law enforcement. So they're saying that, okay, so in general, okay, I get it now. So in general, right, can't do unlawful killings. However, there is an exception for when it's done so by the military or law enforcement that could be at the result of taking some action, right? Excuse me. Because an unlawful killing, so I guess an unlawful killing would be any type of murder that would technically had not been authorized by like the judicial system, so i.e. the death penalty. And so, right, because what notwithstanding the death penalty, I don't think there's any other way you could kill somebody legally, right? And so then therefore law enforcement and the military have an exemption just because of in carrying out a duty or something, somebody could literally die. And then of course this is outside of then, like, you know, the civil stuff where, like, you know, some civil statutes, you know, grant the use of self-defense and whatnot. So I guess that part makes sense. So okay, so I understand this now a little bit better for that part. Applicability of federal criminal laws and the Constitution to contemplate it lethal operations against blah blah blah. Yeah, so these would be the terrorist actions, right? Terrorist operations. See also brief for United States, blah. I express no view about the merits of that interpretation, but it shows that the threshold question of statutory interpretation is a non-trivial step. If the statute covers the alleged official conduct, the prosecution may proceed only if applying it in the circumstances poses no danger of intrusion on the authority or function of the executive branch, right? So I mean, that literally brings us right back to the question about the president ordering SEAL Team 6 to kill somebody that they deemed as a terrorist threat. Because, okay, So this is what I'm pretty sure they're going to argue, and I can already see, like, I can already kind of think of how Shapiro will probably present it, right? Saying that the president has the authority to order Scene 6 to do whatever the president wants. He doesn't have authority to kill, say, a political rival because it's illegal, right? Because there's no reason or justification for it. And I bet you he's probably not even going to address, right? Or nobody's going to address the fact that because the president has control over all of the investigatory bodies of the executive branch, so FBI, CIA, the military, then the president, in communication with the head of said branches, or sorry, branches, head of said departments, could structure the allegation that a political rival is actually working with terrorists, and then order somebody to kill said person, and it couldn't be questioned. You can't get to those conversations because those conversations are immune, right? Because he's the president of the United States who has core power over, like, how he deals with his officers and whether he chooses to fire them. So, like, if he says, I need you to find Pelosi to be a terrorist, or find something to show that she's a terrorist, I'm not going to do that because that's illegal and we have no indication or anything like that. Good, you're fired. We'll find somebody that's actually willing to do it. That can't be admitted in evidence. He finds somebody that's actually willing to do it. Somebody actually goes through the process of doing it, whatever fabrication they have to do. They could say that it was in direction of the president. The specific direction can't be looked at or prosecuted because it's a core function of the president's power to communicate with his officers. So it can't even be admitted in evidence, right? That's what we read so far. So that's what I thought he was going to, like, make it a little bit clearer, but no, he literally brought it right back. He literally brought it right back to the same problem. Danger or intrusion of authority and function of the executive branch, right? Because, believe it or not, making that distinguishment between, you know, whether the president can communicate this to be the communication in something that's clearly unlawful, and trying to distinguish that between something that is lawful, right, would intrude into his authority and function to be able to do it in the first place. Therefore, unquestionable. It's unquestionable, period. It is literally unquestionable. That's crazy. I'm going to just put here, right back to the same problem of not being able to question actions and their motive. I think maybe it's just motive here. Probably motive. But I'm going to just leave that on there. I don't even have to make a note because that's just crazy to me. On remand, the lower courts will have to apply that standard to various allegations involving the president's official conduct. Some of those allegations raise unsettled questions about the scope of Article 2 power, but others do not. For example, the indictment alleges that the president asked the Arizona House Speaker to call the legislator in the section to hold a hearing about election fraud claims. Yeah, I mean, that at face value shouldn't be illegal or shouldn't be used as evidence. The president has no authority over state legislators or their leadership, so it's hard to see how that's crazy though, right? But he's hold on. He's asking the legislator of the state to hold a hearing. Asking and directing them, right, I think would be two different things, right? Because wouldn't the argument just be that asking the legislator to do something versus ordering them to do something would be a different thing? If he was telling them to hold a hearing about their election fraud claims, then yeah, that'd be out of his scope. And if he's asking them to do it, like, how would that be any different than asking the governor to have his state consider passing a law to make a certain thing illegal, you know? Or to, like, revise an order. I don't see how I don't know. I actually for the president's part of it, I actually didn't see like how they would challenge that, because he's asking, it's an official communication with a state body, right? Asking them to do something, but not ordering them to do something. I don't know. Maybe I'm reading that completely wrong. I'm probably reading it completely wrong just because my brain is slowly fizzling out. So just keep that in mind, because as time goes on, we start to drop in our comprehension ability over here. Okay. Cutting him from crimes committed. So cutting him from crimes committed when dealing with the Arizona House Speaker would unconstitutionally intrude on executive power. Is that right? Is that right? So it is hard to see how cutting him from crimes committed when dealing with the Arizona House Speaker would unconstitutionally intrude on executive power. Wouldn't it be a form? I guess technically he has no authority. Does he even is there even a requirement or something that he communicate? So I guess that would make the distinguishment, right? Whether he's required or empowered to communicate with state legislators. Maybe it's just the governors. So if he called the legislative body directly, maybe that would be the case. But he could easily circumvent that by just talking to the governor directly, right? Because I'm sure there'd be some official authority for him to communicate with the governor somehow, and so it would at the very least be presumptively immune. I don't know. I'm just throwing ideas around here. This two-step analysis considers first whether the statute applies and then whether its application to the particular facts is constitutional. Is similar to the approach that the special counsel presses in this court. Brief for the United States. It is also our usual approach to consider the validity of statutes in situations raising a constitutional question. Blah, blah, blah. An important difference in this context is that the president is entitled to an interlocutory appeal of the trial court's ruling. I feel like, didn't we look at this word before? Interlocutory? Just want to make sure I'm pronouncing this right. Is that interlocutory? Given provisionally, yeah, we did look at that word before. I was like, the word sounds familiar. I don't know why I'm like drawing a blank on it over here. But interlocutory, but I didn't even know how to pronounce it.
Interlocutory.
Interlocutory. Okay, appeal of the trial court's ruling. A criminal defendant in the federal court normally must wait until after trial to seek review of the trial court's refusal to dismiss charges. Yeah, so he's saying, but where trial itself threatens certain constitutional interests, we have treated the trial court's resolution of the issue as a final decision for purpose of appellate jurisdiction. So on one hand, he makes the argument that under normal circumstances, right, before you could challenge or say anything, you would have had to wait for the court to go through its process. But that in itself would be a problem, I think is what he's saying here. But where trial itself threatens certain constitutional interests, right? Because that's what the constitutional interests are. We have treated the trial court's resolution of the issue as a final decision for purposes of appellate jurisdiction. So, because after a trial has finished, it's not normally said and done until after all of the appeals are exhausted. We have basically made the determination that the trial doing the action of whatever judicial review in itself could be considered a final act because it would encroach potentially on the constitutional interests. That's how I think I'm understanding that, right? Because then it would be a violation of all the other stuff that they just said is not allowed. Yeah, it's not allowed in the Constitution. So it'd be a problem. The present circumstances fall squarely within our president authorizing interlocutory review. When a president moves to dismiss an indictment on Article 2 grounds, he makes no challenge whatsoever to the merits of the charge against him. Allowing interlocutory appeal of rejection of double jeopardy defense. He instead contests whether the Constitution allows Congress to criminalize the alleged conduct, a question that is collateral to and separable from his guilt or innocence. Oh, we're getting into the legal territory here, where my brain is starting to go on fire. I sort of understand, but not really, right? Because they're saying Congress's ability to criminalize it, right, in itself is a completely separate issue, right? It's a collateral, so it stems from like the question at hand, but is separable from like the trial's purpose of finding him guilty or innocent. I think is how I'm understanding that. Moreover, the president's executive branch authorities would be significantly undermined if appellate review of the constitutional challenge were postponed until after conviction and sentence. So they're saying, right, because remember, they said that normally, like, a person would normally wait for the trial to go through its entire process before challenging it and all this other stuff, right? That in itself of just going through the trial would be an encroachment or would be a problem, so it can't be allowed, right? The president's executive branch authority would be significantly undermined if appellate review of the constitutional challenge were postponed until after conviction and sentence, right? So having to wait till after the trial would be a problem. Even though everybody else has to do it for criminal things, the president shouldn't be subjected to that. Hear ye, hear ye, I knew king. So let's see. Allow interlocutory appeal of refusal to dismiss an indictment on speech or debate clause grounds. The prospect of a trial court erroneously allowing the prosecution to proceed poses a unique danger to the independence of the executive branch. Yeah. So like I said, this can't even be hashed out in court because it would be a problem. It would be a problem for the executive branch. This is so crazy. This is so crazy. As the court explains, the possibility that the president will be made to defend his official conduct before a jury after he leaves office could distort his decision while in office. These Article 2 concerns do not insulate the president from prosecution, but they do justify I hate that they do this, right? This is of course insulation, right? If it can't even be brought before the court to begin with, like inherently that means that it's just like he's just immune and he's being insulated from prosecution, because if the prosecution has to do with any conduct official, then it can't be prosecuted. That's what that means. Why do they sit there and try to like present it to you as if like it's saying that he's not insulated from prosecution when he's clearly being insulated from prosecution? This is I don't understand that. I've got to be reading this. I'm gonna just chalk this up to the fact that I am not an attorney, not a lawyer, right? So maybe I'm not understanding something entirely, but as I read this, it can't be interpreted as any other way. He is protected from official acts. Official acts can't even be like looked at in the court system. How does he not be insulated from prosecution if the prosecution can't even happen to begin with? I don't understand what that statement means. But they do justify interlocutory review of the trial court's final decision on the president's as applied constitutional challenge. Agreeing that the president has a right to an interlocutory appeal from the district court's rejection of his immunity defense. I understand most of the court's opinion to be consistent with these views. I do not join Part 3C, however, which holds that the Constitution limits the introduction of protected conduct as evidence in a criminal prosecution of a president beyond the limits afforded by executive privilege. Okay, so because I was like, I might have to go back to Part C, excuse me, to read it. But so this is the part where like the Supreme Court basically said that his official conduct when it comes to talking or writing to his officials, people that he, because of the nature of his official acts, any of these statements, any of these verbal stuff, written stuff, all that stuff cannot be put into evidence, period. So if he sits there and he talks to his attorney general and he's like, I need you to go investigate Barack Obama for something, make sure that the law enforcement have the authority to protect themselves from any hostile acts that could mean lethal force can be used, and then make sure law enforcement does so in a way where the president might former president offer reaction, like responds in a retaliatory manner, and then make sure that we have the right law enforcement that would argue that they was in fear from his life because the president yelled at him and shoot him dead. This is what I want you to do. And then the attorney general is like, no, that's absurd. I don't want to do that. Okay, you're fired. I'm going to find somebody that actually does it. he finds somebody that actually does all those things, right? To show that it was all set up just so he can kill the former president Obama. You can't admit that in the evidence at all, period. That is off the table. So this is what he's saying, right? That's what I do believe is what he's referring to, right? When he says that you can't introduction of protected conduct as evidence, right? He's saying that's what the Supreme Court had decided. It said that stuff can't be added. What that scenario I just laid out to you, where the prosecution would have him dead to rights off of that conversation that this is what you intended to do, and that's what actually happened. So like the link is clear, off the table. Can't add that as evidence. Therefore, the man walks scot-free. It's crazy. So he's saying that he would have disagreed with it. And so he seems to be a balanced judge here. I disagree with that holding on this score. I agree with the dissent. And it's Sotomayor. The Constitution does not require blinding juries to the circumstances surrounding conduct for which presidents can be held liable. Oh yeah, here's the bribery thing. Oh cool. We actually went straight to the judge and actually talked about the bribery. Consider a bribery prosecution. Our charge not at issue here, but one that provides a useful example. The federal bribery statute forbids. It says forbids. Oh, sorry, it's not it's not working. I thought I disabled it. It still came up. The catch command doesn't work yet. I gotta go back and like fix it because I don't know why it's not reading the other channels, because it was originally meant for YouTube. I know it was originally meant for YouTube, but Kick, but for whatever reason, it's just not reading it, and it's a really complicated bot, so I have to dig in through the implementations and like how the feedback is between Kick and the bot, YouTube and the bot, Twitch and the bot, because I'm streaming all those platforms all at once. So yeah, sorry, but we're gonna get there though. We're gonna get there. All right, with all growing pains and like trying to get the streaming stuff up. Do you stream often on Kick? I do. Every time I stream on Kick. The only time I have a hiatus like this past week is when I actually have a lot of stuff going on in trying to get the stream better. So I just spent this whole week.
Hey guys.
Oh.
Hey guys. We have a new Kick follower.
Thank you, Dune, for the follow. Yeah, I spent all of this week actually getting like stuff like that, like all fixed up and stuff, because I didn't have any of that. Like I have to do all this myself, obviously, right? So the bots, right, which don't work, so I gotta get them working. All of the cool little graphical stuff that pop up when things happen like that, raids, things like that. That's all stuff that I do and work on. This court shit. No, like this court stuff, bro. This court stuff is crazy. It's crazy. Like we literally, if you want to be super reasonable, right? I'm a Republican, right? I'm a registered Republican, but I like to keep it balanced and equal, right? I don't sit there and like meat ride a lot of the stuff that like the Republicans be sitting here and do when it comes to Trump, for sure. But like, if you wanted to be really generous, trying to look at it in the best of light possible, this has made our president close to being a king. The president has a lot of immunity and protections that is actually crazy. That scenario I just gave to you about like his Justice Department, getting his Justice Department to orchestrate all that stuff so he can like present it as a legal means of killing like the former president because like of setting up the situation. The key thing you would need to prove that happening would have been the conversation between him and his attorney general. Can't do it. Cannot be entered into evidence in the judicial process, period. That's what they earlier in my stream when we was reading like the first part of the court stuff, where we read the first little part of the court stuff before we got to the actual opinions. We're only going to read Barrett's which is a particular judge, his opinion, because it's short and he agrees with some stuff and disagrees with some other stuff. And so and so I think like his will be pretty cool to read, and then we're gonna start like looking at videos of what other people have been saying about it. I'm so curious what legal experts think about this case. I would be curious too. Some people I have seen so far or like had glimpse of are saying that this is like absurd. Like the kind of requirements that this court case has just laid out for you to be able to try to prosecute the president or to determine if you can even prosecute him, they basically made it out of thin air, is what is the common phrasing that they're using, where like this isn't based off of anything, nothing. No, you can't turn to anything in our constitution and our history, right, on like some of the requirements. And so like this is just all just to like basically give the president the immunity to basically do what he wants, because it's so convoluted in trying to determine. I'm gonna give you the nutshell of this case, right? This court case basically said this: when the president of the United States is doing anything that is officially allowed from the Constitution, meaning that our Constitution says the president can do this thing, it cannot be prosecuted, period. There is no circumstance whatsoever. He has absolute immunity from anything the Constitution authorizes him to do. So when the Constitution authorizes him to use the military to conduct a military action, like protect the interests of the United States against all threats, foreign or domestic, or whatever, especially like the foreign ones, right? He can't be prosecuted for it, right? So if he goes out, and that's typically was understood, right? When he goes out and orders a terrorist to be murdered, right? You don't sit there and be like, okay, we're going to prosecute him because you didn't let that terrorist get his due process, and not being free from other whatever constitutional protections, right? He just gets to kill him, and then that's it. That's the end of it. No prosecution, right? That was already understood. They took it a step further and said that like just the action. So even if you could think of scenarios where that could be used in a illegal manner, like, hey, I need you, right? I want you to go kill the Korean. You know what? Korea. Oh, it's a perfect example. Korea threatening us with nuclear weapons. I'll bet. All right, military, let's go ahead and let's like destroy that whole piece of land, free from prosecution, right? Korea was threatening us, therefore I blew them out of the water. Boom, that's it. Shit's wild. Would impeachment be the only thing that could penalize it? Impeachment was always the only thing that could take the president out of office, but you got to remember, impeachment is not a criminal process, period, right? So like what was it, like Nixon stuff, like when Nixon did all that stuff, right? He was facing impeachment, then he resigned. Then who else you had the guy that was getting like, what is it, getting head in the Oval Office? What was the president's name, boy, that was getting it in behind the desk? Who was it? Clinton, right? Yeah, there we go. Yeah, Clinton, right? Yeah, it's just, you just get kicked out of the office, right? If you did anything illegal, like it doesn't matter. So right now, before this hearing, right? If Biden was to have like came down and he went to Congress and like punched like Mitch McConnell in the face, right? Assaulted him, right? Then Congress could be like, oh yeah, that's crazy, we're impeaching you. And then he'd be impeached, and then he could, and then that was it, right? That's it. There's no criminal thing behind that, right? So, and I don't even think he could even be sued. Like he couldn't even be civilly sued, like for damages or nothing like that anyway. Would you say it's because of Trump's judges, or do you think this ruling could happen anyways? No, this is only because of the Trump judges. The Trump, he made sure to appoint judges, right, that were, let me go back, right? This is what, page 66? Because they have it written in here who did it, right? I can tell you right now, right? Who are the Supreme Court judges appointed by Trump? Trump with his first Supreme Court nominee, Neil Gorsuch. Trump with his second Supreme Court nominee, Brett Kavanaugh. And Trump with his third Supreme Court nominee, Amy Coney Barrett. I think she's the one that dissented, but I think these two are the ones that actually agreed, right? Did I read that right? Let's see. Roberts delivered the court. Gorsuch and Kavanaugh. Yeah, see? So these two right here. These two judges that he appointed, he appointed 2 or 3. He appointed 3 judges. I think he might be the first person to actually have been able to pull that off. Well, something's got to happen if the Supreme Court, because I think the Supreme Court is like became a very, very powerful branch now. Hell, I think that's the reason why Israel, right? Didn't Israel, like, I think we looked it up earlier, right? Israel sat there and stripped like some power away from the Supreme Court because like it is getting a little crazy. But yeah, this is only possible because of the two judges that that Trump was able to push through. Because it's like what? Like it's like currently what? Nine judges? Is it 9 judges? How many judges are in the Supreme Court? Right? How many judges are in the Supreme Court? 9. Yeah, so it's 9, right? So we had, let's see. So you had Roberts, Thomas, Alito, Gorsuch, and Kavanaugh, right? So 1, 2, 3, 4, 5, and then the 4 that would have dissented. Well, actually, I don't even think, because I think what? I think what? Barrett even joined too, so that's 6. So that would have been 6 out of 3. I don't know if you would have considered his dissent. He would have just like maybe argued, be like, all right, whatever. Maybe, I don't know. I don't know necessarily how it works. 9. So that means that like if you took out 2, so if you had 6 and you took out 2 of them and you had them with judges that were a little bit more like sane, then yeah, this wouldn't have made it. There would have been enough dissent to like change this. So yeah, so this is definitely like what the Trump Supreme Court I guess gives you. It's crazy. How many pages we got left? Okay, cool. We only got like one more page. So let's see. So I'm gonna finish this and then we're gonna look at the video between what is this? My other guy gave me. Yeah, Shapiro on Destiny. So let's see. I agree with dissent. The Constitution does not require blinding juries to the circumstances surrounding the conduct for which the president. Roe, now this. Oh yeah, Roe. Yeah, Roe. This, and yeah, Chevron. Chevron was another one. Chevron maybe could be a little bit more reasonable arguments to be made about why that needs to be overturned. But yeah, them boys, the Supreme Court boy, them boys got everything on the chopping block. The Constitution does not require blinding juries to the circumstances surrounding conduct for which presidents can be held liable. Consider a bribery prosecution, a charge not an issue here, but one that it provides a useful example. The federal bribery statute forbids any public official to seek or accept a thing of value for or because of any official act. Excuse me, my God. The Constitution, of course, does not authorize a president to seek or accept bribes, so the government may prosecute him if he does so, right? We know this, as an impeachable offense. See, blah, blah, blah. Okay. Conflicts of interest. So, to conflicts of interest arising out of president, blah, 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 Rockefeller. Okay. Oh, no, so this is actual stuff to read. I don't know why they wrote it like this. It's killing me. I'm gonna hit the hey. Good luck with the reading grind. I'll make sure to drop by next time you stream. I appreciate it. Yeah, we typically stream like pretty late. Sometimes, especially over the weekends, so we'll do we'll do a little bit earlier streams, but we typically we're a night owl when it comes to the streaming. So, but yeah, I'll catch you next time, brother. Thank you for joining. Let's see. So, conflict of interest sounds good. Peace, stuff. Take care, fam. Let's see. Under the 25th Amendment to the Constitution, suggesting the federal bribery statute applies to the president, yet excluding from trial any mention of the official act connected to the bribe would hamstring the prosecution. To make sense of charges alleging a quid pro quo, the jury must be allowed to hear about both the quid and the quo, even if the quo standing alone could not be a basis for the president's criminal liability. I appreciate the court's concern that allowing into evidence official acts for which the president cannot be held criminally liable may prejudice the jury, but the rules of evidence are equipped to handle that concern on a case-by-case basis. Most importantly, a trial court can exclude evidence of the president's protected conduct if it is probative. If its probative value is substantially outweighed by a danger of unfair prejudice or confusing interest. I like how he wrote this here, because what this is basically saying is that, like, we could be allowed to add the official stuff in the evidence and then make a determination based off of each of it case by case if it should be allowed to be used or not for enroachment. So in the case of bribery, right, we could allow a communication to be admitted into evidence if it's being alleged that the president did an official act that would be in that is due to a bribery, right? That would encroach into that shouldn't encroach into his constitutional protections, because he's not supposed to be doing those constitutional things at the behest of somebody because of a bribe that they're giving him. So I mean, to make that part makes sense. And so that could be something that would be that they could have easily carved it out to where, like, for bribery allegations, we can allow the, you know, official conduct to be heard about to see if it can be used as evidence, right? If the president during his day-to-day hears, like, you know, lots of people offering him stuff for bribe or for pardons, and it's not necessarily clear whether he actually accepted a bribe or not. It just so happened that, like, somebody made a donation, somebody related to wanting the pardon made a donation to, like, maybe his, like, organization or something. Maybe that could be hashed out and found not admissible because, like, there wasn't necessarily any communication to indicate that he was going to pardon them because of that donation, you know? So, like, if I was seeking a pardon from the president and I was already going out my way to, like, donate to his organization, and I try to offer him, say that, hey, I'll make triple the donations if you, like, pardon me, and the president doesn't respond, and I do it anyway, and the president does actually happen to grant me my pardon anyway, I don't see that communication being entered in evidence, because it wouldn't necessarily be clear that he did it because of my tripling of the donations, right? I don't know. That's just like my off the cuff kind of thought behind it. Most importantly, a trial can blah blah blah. Oh yeah, most importantly, a trial court can exclude evidence of the president's protected conduct if it is probative. If it's probative, I gotta figure out how to say this word right. Probative, right? I know what probative means. I just want to know how to pronounce it.
Probative.
Probative. Okay. Probative value is essentially outweighed by the danger of unfair prejudice or confusing the issues. Blah blah blah. Requiring the court to restrict the evidence to its proper scope and instruct the jury accordingly. The balance is more likely to favor admitting evidence of an official act in a bribery prosecution, for instance, than one in which the protected conduct has little connection to the charged offense. If the evidence comes in the... Okay, actually, I think this little sentence here is important. One in which the protected conduct has little connection to the charged offense, right? So I think what they're distinguishing here is that the protection from the Supreme Court is that you ought to not look at the president's motives or, like, his communications or things like that would hamstring his ability to make judgments. And what they're saying is that that's cool. And what he's saying here is that's cool, but they can easily be carve out exceptions for things that are not directly related to the charged offense. So if you're trying to, like, if you was trying to charge the president for... my thing on? It's not. That's concerning. If you was trying to charge the president for an act, right, for whatever act it is, and you was trying to include things that aren't necessarily directly related to that act, then it shouldn't be. But, you know, it under normal circumstances, it could be used for evidence, but, like, that the thing in itself is not directly related to what's being what he's being charged for, then it shouldn't be allowed in the court. And then the carve out would be for things that you could say is directly related. So, i.e., communications directly tied to accepting a bribe to do this action, right? I think is what is being said here. I botched that whole explanation, so do forgive me on that. But we're getting a good understanding of it. And if the evidence comes in, the trial court can instruct the jury to consider it only for lawful purposes. I see no need to depart from that familiar and time-tested procedure here. The Constitution does not insulate presidents from criminal liability or official acts, but any statute regulating the exercise of executive power is subject to a constitutional challenge. A criminal statute is no exception. Thus, a president facing prosecution may challenge the constitutionality of a criminal statute as applied to official acts alleged in indictment. If that challenge fails, however, he must stand trial. So, okay, he's saying that what at least should have been allowed is that it go through the court process and then he challenges the constitutionality of it, right? Because remember, the immunity that they just granted the president is that stuff can't even be hashed out in court, period. It can't be allowed into the court system, period, because it's about an official act or a presidential power. Therefore, it's not allowed. Okay, and then we get into dissenting, which is what we're going to stop here for reading this document, because I think just the beginning part of it was enough for me to kind of get a good understanding of what that case is. So now we're going to actually look at the this video. But before I do that, I am going to make me a bowl of cereal. And I'm only going to do such a thing because I need I need to put these batteries on the charger too. I need to be able to use up all the milk before it expires, because I think I got 2 days left. And so the milk's almost done, just not quite. I need to kill it. So let me now first I'm gonna check the temperature of my laptop, see how my laptop's doing over here. 72 degrees. Okay, yeah. So having a fan on, I think really helped out, because I forgot that's the whole reason why I bought that damn cooling pad. Okay, cool. So 72 degrees, so it's good there. Let me now. Oh yeah. So I'm going to switch scenes here. Ooh, I need to make a transition. I want to make a cool transition effect too. That's what we'll work on next time. Ooh, man, I got so many